May I have your attention, please? All rise. Lawrence County Municipal Court now in session. The Honorable Donald R. Capper presiding. All those having business before the court draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. Today is June 24th. I'm Judge Capper. We have a very large docket today, so try to be patient. We'll get to your case. We've got several review hearings, so those are people who have court orders to comply with. This is a check to see if you are compliant. When your name's called, come up to the table. To your right, stand there. I'm going to go over the file with you. Call the reviews, please.
Dakota Kraft, Douglas Dillon, Misty Dotson, Trevor Fitzpatrick, Elizabeth Hoffman Howard.
Okay, Dakota Kraft is here. It is case number 2320, 22-130. He's at Bethesda. Got a report from Bethesda. Okay, overall good report. There's still things you're working on, is what I'm reading into this.
Yes, sir.
So keep doing that. Are you able to put anything on your files today?
No, sir.
Are you working yet? Okay.
Can't.
Not yet. Okay. I'm going to make it August 5th as your next hearing, review hearing.
Sir.
Okay, keep working. You're doing good.
Thank you.
August 5th, 9 a.m.
Thank you, Your Honor.
Thank you. Your name?
Misty Dotson.
Misty Dotson is 23706 OBI.
And I have this too, if you want to give this also to him. He can keep it. I have another one.
Okay, you're at Marshall Health?
Yes.
And through ProAct?
Yes.
Okay, are both of these for me, or do you want this one back?
No, you can keep it if you need to.
Okay.
I have an extra one.
All right, you're doing what you need to do at ProAct, so that's good. You've got some community service and fines to pay. When can you start working on those?
That's what that letter is about, sir, Your Honor. Right now, I'm not able to do community service.
Well, you have to go to jail then.
I mean, I got issues going on with my legs, but I'm going today to find out what's going on.
Because you got a jail sentence which suspended, and part of the suspension was that you did community service, so.
Okay.
I'm going to assume that you'd rather do the community service. This
Yes.
doesn't say you can't do community service.
Yes,
So, you got to do the community service or you got to go to jail. Those are your two options.
I'll do the community service.
Okay, that's what I thought. Smart decision. Have you ever been to the jail?
Most definitely.
Okay, I have too, just for a visit. I've never spent the night there, and I would not want to spend the night
No,
there.
you would not.
All you folks that are here, you need to do whatever you can to stay out of the jail. It's awful.
It's horrible, let me
All
tell you.
jails are awful, but ours is particularly awful.
Horrible.
So if you do some community service and stay out of that place, it's not that bad. We'll figure it.
I'll get it
We'll
done.
accommodate whatever your issue is, but you come out and make an effort and get it done. You got 5 days to do it. So you need to start coming out and doing it.
I will.
No excuses. This is a no excuse place. So it's either jail or community service. And I
Community service.
haven't had anybody yet say, I'm so bad, I'm going to go lay it out in jail. Nobody ever says that.
No.
Okay, your next hearing July 26th. That's a Friday, July 26th, 9 o'clock. Okay, Douglas Dillon, 2133. Douglas Dillon has been called, has not finished, and hasn't appeared, so he gets a warrant. for
Thank you.
You're welcome. Trevor Fitzpatrick is on teleconference. 23379 and 23232, 23384. Okay, you still have community service to do. Are you there, Trevor? Okay, I see you.
Yes, sir.
When are you going to finish your community service?
I'm coming back home Tuesday. Right now I'm in Sanford, Florida. I was on a 3.5-week job down here, so I'll be home Tuesday. And I'm not leaving until the 2nd of next month.
I have a note that Mr. Fitzpatrick was ordered on 5/3 to be here on 5/4, and he did not show up.
What do you say to that, Mr. Fitzpatrick?
I'm sorry, I didn't hear.
Mr. Cooper says that I ordered you on May 3rd to be here the next day, May 4th, and you didn't show up.
Was that the last hearing that I had?
Yes, it was.
I'm pretty sure that I went out of town the next day. Was that on a Friday?
It was on a Friday.
I went out of town Saturday. If we need documentation of that, then I can provide that.
Well, here's the thing. Here's the thing. If I ordered you to be here, you gotta be here. Going out of town is no excuse. So, when are you coming back into town?
Tuesdays. I'm flying home Tuesday.
This coming Tuesday?
Tomorrow. Yes, sir, tomorrow.
Okay, so the 25th. Well, I expect you to be here the 26th, or I'm gonna issue a warrant for you.
Yes, sir.
Do you understand? Is that clear?
Yes, sir.
No doubt about it?
Yes, sir.
And you can be here on the 26th?
Yes, sir.
No excuses. Okay, and just to make sure, I'm going to put it back on the docket for the 28th. Your next hearing is June 28th, and I expect you to make the payment by then, too. You've been working. June 28th for a review hearing at 9 a.m. Okay.
Yes, sir.
We'll see you Friday at 9 and see you on Wednesday for community service. 7:30 a.m. Elizabeth Hoffman Howard. Okay, she always comes late, so I'll put this aside. She usually gets here late. We'll recall later in the doc.
Ashley Huff, Allison Littleton, Ellen Phillips, Donald J. Porter, Jessica Prince, Matthew S. Smith.
Okay, Ashley Huff is here, 2724, 725, 2758. Can you make a payment today?
$40.
Okay, you're getting close to being finished.
Good enough.
August 5th, is your next hearing. Once you've paid it off, you can still come if you want to, but you don't have to come.
I'm good.
August 5th, 9 o'clock. See the clerk. Allison Littleton, 19540.
I have one of the papers that you were requiring. I have another paper from the president of Friends of the Library where I did my community service that is being mailed to me. It just didn't get here in time for court this morning.
Okay, that's a good report from Pathways. Okay, so is that Moorhead?
It's Ashland.
Ashland, okay. Is that something that's been approved, or is that?
I would have to check, Your Honor.
Okay. Okay, do you have time to speak with her this morning?
Yes, I will.
Okay, I want you to speak with Mr. Cooper about your community service. I'll set your next hearing for August the 2nd. I'm showing a $50 balance.
I can pay that today.
Okay. See the clerk, talk to Mr. Cooper, then you're free to go. If you get things finished by August 2nd, you don't have to come back.
Okay, thank you.
You are. Alan Phillips, 23-546, 23-1249.
Your Honor, if I may, she turned in community service this morning, she finished her up. I believe the one she had was the ODI class.
Okay. Okay, so you're registered for the August class, correct?
Yes, sir.
Okay, so here's what I'm going to do. I'll set you for August 26th, that's after the class is completed. So if you successfully complete it and give us a report in, you won't have to come back on August 26th. You'll be
Okay.
finished. Any questions?
No, sir.
Okay, August 26th, 9 a.m.
All right, thank you very much.
You're welcome. Donald Porter. 18-12-42, 20-21-20, 08-441. You're just making payments on your funds. Do you have a payment today?
Will before the week's out.
Well, can't pay anything today?
I don't have no cash today.
Okay.
I have some Wednesday. I just live like a block away. I come down, log in and pay it.
Well, you either gonna have to do community service or pay. I'll reschedule it for Friday. Do something on it by then. So this Friday, June 28th is your next hearing, 9 o'clock.
All right.
Jessica Prince. Jessica Prince, 11-123. Hasn't appeared, hasn't done anything on her case, gets a warrant for not appearing. Matthew Smith is here.
Yes, sir.
12-627, 14-665, 14-553, 15-457, 21-692. You still have some community service to do.
Yes, sir.
When can you get that done?
I've been doing it on Saturdays. I
Okay,
take
so you'll
days.
be here
Saturday.
this coming Saturday?
Yep.
You have a payment today?
Yes, I do.
How much?
$25.
Okay, he says he'll be here Saturday.
Okay. He was here when he was ordered the last time.
Okay, very good. All right, I'll put you down for 25, set your next hearing for August 5th.
August 5th.
Yes,
Okay.
sir.
Thank you. Have a good one.
You too. Okay, that finishes the review. So next are arraignments. We have something to do here. Okay, we've got arraignments to do here, and then we'll have something to do from the jail also. We'll do this by teleconference. So I want to give the rights of defendants to this group, but if you have questions when your case is called, feel free to ask me questions about your rights. All defendants have the right to remain silent. You don't have to say anything once you're called before the court, but if you do say things, everything you say is on the record, so it's being, not only is your audio being recorded, but your video, so it's all being videoed. If you admit something about your case, the prosecutor could use that against you, and sometimes people do that. You don't have to do that. You don't have to say anything. You have a right to have an attorney. You have a right to have one appointed if you can't afford one. You have a right to have bail and to make the state prove any charge against you beyond a reasonable doubt. If you decide to enter a guilty or a no contest plea, you're waiving those rights. And you should not do that if you don't understand the proceedings, if you want to talk to a lawyer, if you want to have a trial on your case, or if you don't know what to do. You should not enter a guilty or no contest plea. You can always change your plea later. A lot of times people tell me, I just want to get it over with. That's not a good reason to enter a guilty plea or a no contest plea. Call the first case.
State of Ohio versus Crystal Rogers, case number CRB 22760.
This is Mr. Holt's case.
Your Honor, I think we may need Mr. Field in here for this one.
Okay, we'll have Mr. Hill come in. This is an older case. I don't think she's ever been arraigned.
She hasn't, Your Honor. I think my impression or understanding is going to be dealt with before she even needs to enter a plea.
All right, Mr. Hill, this is Crystal Rogers, Mr. Holt's representing. It's an old domestic violence charge.
Yes, Your Honor, it's a 22 case, and I've looked that over a little bit and received a written statement from the alleged victim in this matter, and I don't recall his name right this minute, but I'm
He's
Thomas Rogers.
Yeah, and
You want to come out, Thomas Rogers?
so, Your Honor, if you were to read the statement of the police officer, the affidavit, it really does read exactly like what they're saying. They practically had to try to drag something out of him that would amount to domestic violence even back then. And so I think this is probably appropriate just to go ahead and dismiss today.
Okay, and that's what you want, sir?
Yes, sir.
All right, at your request and the prosecutor's request, the case will be dismissed without cause.
Thank you.
You're on.
You'll wait for us one.
State of Ohio versus Michael Johnson, case number CRB 24323. Michael Johnson.
Michael Johnson, come into court. Michael Johnson was called for, has not appeared.
Did not check in, Your Honor.
Thank you. He was served with a copy of the summons and complaint by residential service on May 30th of 2024. So that's insufficient service. I'll pass it. There needs to either be certified mail or personal service. So case is passed for service on the defendant.
State of Ohio versus Toby T. Morrison, case number CRB 24324, A and B.
Sir, you Toby Morrison?
Yes, sir.
Mr. Morrison, it's alleged that at Rome Township on May the 19th, 2024, you caused or created a risk of harm to property of April Williams without her consent. The charge against you is criminal damaging. That's a second-degree misdemeanor. Carries a maximum penalty of 90 days in jail and a $750 fine. Do you understand the charge?
Yes, sir.
Do you understand the rights you have?
Yes, Your Honor.
How do you plead to the charge?
Not guilty, Your Honor.
Do you wish to have a lawyer appointed to represent you?
Yes, sir.
Are you working?
No.
You have no income?
Correct.
Okay. I'll appoint Mr. Stratton to represent you. This is Toby Morrison. It's a criminal damaging charge. Not guilty plea is entered. he can sign a $1,000 signature bond.
Get your sign right there.
Any day except July 18th through the 22nd.
18th and 22nd are
Yeah.
out.
Yeah, I think it's the 19th and the 22nd.
19th is correct. Yeah, 19th. Work day. Let's do the 15th is okay?
Yeah, 15th.
July 15th will be the next hearing date.
All right. Thank you, Your Honor.
That'll be at 10 o'clock for a pre-trial.
All right, thank you.
Not guilty, please enter.
All right.
Thank you.
State of Ohio versus Brianne K. Williams, case number CRB 13-1007.
And you're Brianne Williams?
Yes,
Ms. Williams, it's alleged that you missed a hearing way back in 2014, May 23rd, 2014, on a theft offense.
correct.
And I don't know, did you get arrested on this, or you just decided to come in on your own?
I just decided to come in.
Okay.
I
Paid off
was
your
getting
fines
a
and
job.
court costs.
Huh?
You did pay off your fines and court costs recently.
Yeah, when I found out, how I found out was, I was applying for a job and that ended up coming back. I've had several jobs since and it never came up. And when I saw it, I immediately called up the courthouse and they told me what steps I had to take.
Okay, I'll withdraw the warrant that had been issued for you, and you've paid your fine, you have 5 days of community service to do.
Okay.
And what's your work schedule?
Right now it's nights and weekends.
Oh, so during the week you could work?
Yeah, daytime.
We have community service here at the court every day but Sunday, so you could do any day, 7:30 a.m. to about 8:30, and
Is that something that I would have to set up in advance or I just show up?
you just show up.
Okay.
Every day. So Monday through Saturday, 7:30 on the west side of the courthouse, just show up there and you'll be assigned something to do that day
Okay,
until you get your 5 days done. So what I'm going to do, I'll set up another review hearing. If you get it done before then, you don't even have to come back to that hearing, because the hearing is to ensure that you do what you're ordered.
correct.
So I'll set it for August 9th, so that gives you a little more than a month to get it
Okay.
done. Get it finished, you don't have to come back, but otherwise be here August the 9th. If you don't finish it, don't show up, you get a warrant.
It'll be finished.
Okay,
I appreciate it. Thank you.
you're welcome.
State of Ohio versus Holly Elkins, case number CRB 24-387, A and B.
You're Holly Elkins?
Yes, Your Honor.
All right, Ms. Elkins, it's alleged that on June 17 in Fayette Township here in Lawrence County, you purposely tried to deprive Walmart of property without their consent. It's a theft charge, maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, Your Honor.
Do you understand the rights you have?
Yes.
How do you plead?
Guilty.
Guilty means you're admitting it's true, and overlook, there's another charge. You had theft and criminal trespass. It's alleged that you went on the premises of Walmart without the right to do so. So that's a 4th degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand that charge?
Yes, Your Honor.
How do you plead to that?
Guilty.
Okay. And you have a Jackson Avenue, Huntington address, is that correct?
Yes.
All right, well, what I do on just about all these is require a urine screen before I sentence you. So go see Mr. Cooper, he'll show you where to go to get that completed. When I get the results, we'll come back and I'll sentence you to that after I get the results.
Okay.
State of Ohio versus Kyle L. Akers, case number TRC 22-2527 A and B, CRA 23-378.
Mr. Delaware, please.
It is, Your Honor. And you've got, I think you've got two files there.
Yes.
One of them, I think, is a matter that involved a warrant that had been issued for Mr. Akers out of Meigs County, which he's taken care of, and that case is resolved at this point. And the other one, I think, is an OVI that maybe Mr. Akers missed a review hearing on. And here's what's going on with Mr. Akers for your information. So he's been incarcerated for approximately the last year. He was first incarcerated in Boyd County, and I think that ran from about April of last year through about December of last year. And then when he was released from Boyd County, he had to deal with the thing in Meigs County. He went to Meigs County. They required him to go to the STAR program. So he successfully completed the STAR program. And then the day after he got out, he contacted me, indicated to me he had a warrant issue in your court and a warrant issue in Boyd County, Kentucky. So Friday we went to Boyd County, Kentucky. We took care of that warrant, and he's on probation over there. And then we're here today to try to get back in good graces in this court.
Okay, well, one issue in that history is the 22 OVI charge here has never been resolved. I mean, it's still pending. He pled guilty by my notes on December the 8th, and we delayed sentencing, and then it just never happened because there's other issues.
Understood. Okay.
So what I'd like to do, we'll either have to come back for another hearing or do some checking today. I want to verify that because there had been a warrant out of Meigs County.
Right.
He also had that pending. And he had a bond up with Mr. Sowers. And I think Mr. Sowers has been looking for him also. But if we could have the prosecutor check to see if Meigs County has withdrawn their warrant, and then go ahead and sentence him on the OVI today also, if that's agreeable.
Yeah, that'd be fine. Can we call this back
I'll play
up?
it, give the prosecutor a chance to check on the Meigs County
Sure.
warrant, and you all can talk about sentencing, how you want to handle that. Later in the docket, I'll call it up and see if we can't resolve the whole thing.
Okay. That sounds good. Thank you, Your Honor.
You are-
Kyle Akers. Kyle, just have a seat there. I'll give you his information.
The case number here was CRA 23-378, which was a Rule 4 hearing to Meigs County.
Let me give you his, your social security number and birthday.
State of Ohio versus Neil R. Bouchelon, case number CRB 24-392. Neil Bouchelon.
If you are Neil Bushel, I know that to be a fact. It's a restraint of dog charge. It's alleged at Rome Township on June 21st. You failed to restrain a dog and find it on your premises. And for some reason, this filed as a 4th-degree misdemeanor, which is a little unusual. Usually they're minor misdemeanors. So that's actually a jailable offense. Maximum penalty is 30 days in jail, $250 fine. So I'm going to enter a not guilty plea for you.
Thank you, Judge.
He can sign a $500 signature bond. Good for you to help him with that. You can get Mr. Smith to help you with your defense.
Thank you, Judge.
And we come back on Mondays and Fridays, so that's when we have to work. You can try to see if you can work out something today with the prosecutor.
Okay.
He is a dog lover. If you have pictures of your dog, that would probably help.
Okay. Your Honor, the reason why it's a 4th-degree misdemeanor is because it's alleged that the dog bit somebody.
Oh, okay. Well, how about July the 5th? It's not a great day for staff and everybody to come in, but I'm going to be here. Are you out of town?
I'm supposed to be out of town, but Judge, if you want it that day, we'll have it that day.
A different day. How about the 8th?
8th is good.
All right, I'll set it for July the 8th for a free trial.
Thank you, Judge.
You're welcome.
State of Ohio recalls Holly Elkins, case number CRV 24387, A and B.
Okay, it's acceptable, Green. Anything you want to tell me before I send you?
No, Your Honor.
Your Honor, if I may, there's a warrant for her, they're pulling the file.
Oh, out of which?
I believe it's out of our court.
Out of this court, okay.
Yes.
Well, just have a seat, we'll call you back up after we get that additional information.
State of Ohio versus Timothy Adkins, case number TRC 231834, A and B.
It's Mr. DeWaters' case.
Sure.
Your Honor, we've had a couple of pre-trials on this, and I've talked to Mr. Hield about, there's one last issue that I want to look into before we can resolve this. I don't know, I think I've got some hearings up here on July 22nd. I don't know how busy your schedule is on that day.
It's not bad. We can set this then if you want.
Can we set this on the, you know what, I just misspoke, it's not July 22nd. August 5th is the next time, is that okay?
Yeah, August the 5th.
And then if we don't have it resolved on that day, Judge, we'll get a trial date.
All right. Mr. Hill, do you have, I meant to ask you this previously. The jury trial that is on the docket for July the 19th, do you believe that's still going to go then?
I haven't spoken with Mr. Eaches following the court's judgment on that motion issue, so it may have changed things or it may not have. I just don't know. I think is he scheduled to be here today?
Yes.
Okay. Maybe we'll find out today.
State of Ohio versus Logan M. Brace, case number CRV 24234. Logan Brace.
This is Mr. DeWaters' case set for pre-trial.
Your Honor, I believe the state's willing to move to dismiss this case on payment of court costs. We have no objection to that.
Hey, Chris. Oh, yeah. Your Honor, we had agreed to do that, and the reason was because we looked at the evidence on this, and there was a co-defendant, a young lady who previously pled guilty to this offense, and we believe that she was the responsible party, and we just happened to make the bad decision to be with her when she did.
Okay. Based on that, the case will be dismissed.
I'll have him pay the court costs before leaving court, Judge.
Okay. Dismissed on payment of costs.
Meet me in the lobby. All right. Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus Robert M. Hackett, case number TRC 1182 A, B, and C. Robert M. Tackett.
Your Honor, Mr. Tackett's not here today. He is incarcerated in Boyd County. I talked to Mr. Heald about this. Mr. Tackett is in drug court in Boyd County, and when he notified them that he got this arrest, they put him in jail. They haven't revoked his drug court yet. They might, but they haven't made that decision yet, so currently he's just being held while they're waiting. In any event, I talked to Mr. Heald about requesting discovery and going ahead and proceeding like we're defending this case over here, although if they wind up revoking his drug court, I'm going to have to ask you to let us do a video hearing or something, and we'll just resolve it that way. But I just don't know the answer to that yet.
Okay.
So if we could have one more pretrial, I may have more information then.
All right, you want that August 5th date?
Yeah, that's fine. Yeah.
Finished request, case is continued to August 5th for another pretrial.
Judge, may I approach? I've got an entry on that Atkins case.
State of Ohio recalls Holly Elkins, case number CRB 23342, and CRB 24387, A and B.
Okay, this is from a prior theft offense. It looks like it was from I'm assuming Walmart when you check. Yes. So that's the reason for the trespass now. You missed the review hearing. March 21st of this year. That's the allegation that you missed a review hearing on a previous theft offense?
Yes, Your Honor.
You understand that? You admit or deny that?
Yeah, I admit.
You have an explanation?
I haven't having car issues, so I haven't been able to make it to community service or over here.
Where's Jackson Avenue? Is that-
It's in the west end of Huntington. But I just got my car fixed, so,
Well, at that time, it looks like you were living in Virginia Avenue.
yes.
Different address.
Yeah, it's just down the block from Jackson.
What's always kind of puzzled me, maybe you can explain this, since now you've got two convictions from shoplifting at the Walmart in South Point. I really don't understand why people go there to shoplift, because they have video cameras all in the ceiling. They have store detectives. If you want to get caught shoplifting, that's the place to go. But I still get a dozen people a week that go there. Isn't the word out you're going to get caught if you go to Walmart to shoplift?
Yes.
Don't people know that? Now, I have been told that some people go there to shoplift and know that because they want to be forced to treatment. And I will force you to treatment if you go shoplift and then you test dirty. I'm going to make you go to treatment. You're not testing dirty, but you shoplifted twice at Walmart. Is there any explanation of why this makes any sense?
No, I just, sometimes, I don't know, I don't know why, honestly. I just felt like I was backed in a corner and You know, I lost my job, lost my car, and I don't have family from here, so I felt like, I thought I could get by with it.
Where are you from originally?
South Point, Ohio.
Oh. Well, you
Yeah.
came home then, I mean.
Yeah.
But you're living in Huntington now, in the West End?
Yeah, I've been there for about 20 years.
How'd you get here today?
My friend brought me.
Okay, well, since this has happened, can you get here? I want you to get here for community service
I'll be here.
several days in a row. Otherwise, you're gonna have to go to jail.
I will do it.
Okay, so I'm gonna sentence her on 387 A and B. You've already been sentenced on the 23 case number. So on 24-387A, I'm going to impose a $150 fine where you pay the court costs, and I'm going to give you 30 days in jail, and I'll suspend it on the condition that you do 10 days of community service, and I want 5 days in a row.
5 days in a row.
Right off the bat. So for the next 5 days, I want you out here every day for community service, 7:30 a.m. I'm warning you to stay out of Walmart, level 4 probation. And I'll set a review hearing about a month out. Let's go August 2nd. August 2nd is going to be your review hearing at 9 o'clock. So I don't want you to go to jail. You can stay out of jail, but you got to do the community service and do 5 days in a row. Okay, you're to meet with Mr. Major about your probation. He's at the security check-in right now, so go talk to him, get your paperwork, and be here tomorrow at 7:30 for community service. Oh, I'm sorry, hold on, we got a criminal trespass too. $50 fine on that. Same, August 2nd.
State of Ohio versus Tyler D. Adams. Case number TRC 23-1866, A, B, and C. This is Mr. Holt's case.
And Mr. Holt in the courtroom. Tyler Adams set for pretrial.
Your Honor, I believe we have a resolution in this matter.
Your Honor, this is he's going to plead.
Yes, Your Honor, I believe, and Mr. Adams has already completed the dip school, and I believe the suspension has already run, both the ALS and the court imposed. In exchange for motion to dismiss the ancillary moving violation charges, Mr. Adams would enter a plea of guilty, and I believe this is a joint recommendation for the main statutory minimum.
Yes, he went to law enforcement.
Correct.
Okay, and I'm sorry, tell me again what the recommendation was.
For plea is the first offense, the low test, the dismissal of the, is it distracted driving and marked lanes in exchange for the mandatory statutory minimums, Your Honor.
All right, do you agree with that, Mr. Adams?
Yes, sir.
Yeah, you have a right to make a statement to the court if you wish, you're not required to. Do you want to make any kind of statement before sentencing?
No, sir.
Okay, I'll dismiss the B and C case. B and C are dismissed based on the agreement. I'll impose a $375 fine on the ODI plus court costs. 6-month license suspension, which was just up the last few days. So what'll happen on that, you need to contact the B and get reinstated. If you're eligible to get reinstated.
So, yeah, I called them and they said I have to go down there and pay the reinstatement fee in Ohio, and then I'll get a paper, and I go to Kentucky and have to pay another one in Kentucky if I'm correct, if I heard them correct.
Yeah, you have a Kentucky license, so you probably need to deal with both.
Yes, I'm going
Ohio's
straight.
going to report it to Kentucky, and
Right.
you have to deal with whatever Kentucky wants you to do. All right, your review hearing is going to be December 23rd. So that's a hearing that you have to show up and explain, if you haven't finished everything you're ordered to do, why you didn't get it finished. Ask for more time. If you don't show up, you get a warrant for not showing up if you have stuff still left to do. In one order, you get a 20-day jail sentence, but it's all suspended on the conditions you get 5 days of community service and go to dip school, which he's already done. He's already finished the driver intervention program. The lane violation and distracted driving are dismissed. So, see Mr. Major, and after that, you're free to go.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Kyle Akers, case number TRC 222527 A and D, CRA 23378.
Okay, this is a recall. We have some information about it.
Yes, Your Honor, we were able to confirm, well, the prosecutor's office was able to confirm that the Meigs County warrant was taken care of and that yours is the only one pending.
Okay, so that's, the Meigs County issue was case number 23378. 23378. That's been resolved, so it can be dismissed. So dismissed due to them withdrawing their warrant. And they were ready to go ahead and do sentencing on the
Yes, sir.
OVI. He had already pled guilty on that. There was an OVI with a refusal and a lane violation.
Understood.
Is there a recommended sentence on this, Mr. Yule?
Your Honor, I believe it's a first offense.
There was actually a prior, according to this, I'm just looking at the citation, a prior in 2020.
Your Honor, here's what we would suggest. I don't think I represented Mr. Akers on that case originally, but I did speak with Mr. Hill briefly. And given Mr. Akers' lengthy recent incarceration, I was hopeful that you would maybe consider imposing a lengthy jail sentence and suspending it in this case on the condition that Mr. Akers continue with his counseling. When he got out of STAR, he got in with AIM and is currently in treatment with them.
The name of it's AIM?
AIM, is that the name of the counseling or just the
Yeah, it's AIM.
MAT place?
It's AIM. That's it. Yeah, they do all of it.
Is that in Meigs County?
No, it's not. It's in Board County. isn't it?
Yes.
Oh,
Summit.
Kentucky, okay. Yeah, that's right. What's the state's position on it?
Well, Your Honor, and it is with the understanding that Mr. Akers has recently completed the STAR program and is ordered, I guess, through his probation to continue in treatment. It would not be uncommon for us to encourage somebody to stay in treatment by indicating that we would look favorably in sentencing recommendation upon a successful completion of that treatment. Now, I don't know, at this point, I think it might be best that we follow him through treatment before the court would pronounce a sentence, given the fact that it's a second offense.
That'd be okay too.
All right, so what I understand, Mr. Gill, to be saying, you're willing to either consider his prior jail as fulfilling the mandatory provision under Ohio law for a second offense if Mr. Akers is successful going forward with his treatment.
Yes, Your Honor.
Okay, So, so what I'll do, I'm going to allow the case to still remain pending. And we'll set it for sentencing hearings, and I need reports as to how he's doing. And he's going to be subject to testing also.
Yes, sir. He's on medically assisted treatment right now through AIM. He was tested Friday when we took him to Boyd County as part of the arrangement over there. So he understands that he needs to stay clean.
Okay. Let's come back on that August 5th day.
Okay.
For a sentencing hearing, and I need a report from AIM as to how he's doing then.
Yeah, I'll get one from.
That's fine.
So that'll be at 10 o'clock, the sentencing hearing on August the 5th.
Thank you, Your Honor.
You're welcome.
What was the date?
August 5th. May I approach on something?
Yes.
You're good now. Do what, keep doing what you're doing. Talk to me, call.
State of Ohio versus Vincente Carlos Quintanilla. Case number PRB 22360 A, B, and C.
Okay, this is on the docket today as an expungement.
It is, Your Honor. It's an application to seal some dismissed charges. And I've discussed it with Mr. Hill prior to coming into court today. I've got a proposed entry that Mr. Hill's also for your review.
All right, I'll execute the entry, and it's, I'm going to entrust that you engage with the clerk about what needs to happen to make it happen.
I'll do that now. May I approach? I'll take it.
Yeah. Thank you, sir. You're welcome.
State of Ohio versus Jacob R. Nichols. Case number TRC 241236 A and B.
Your Honor, I was retained Friday to represent Mr. Nichols.
This is set today as a pretrial, so I'll enter an appearance for Mr. Holt as counsel. Is there anything we can accomplish today?
I don't think so, Your Honor. We're waiting on urine results. So there's no suspension or anything. Just waiting on that.
Okay, so we're probably, yeah. Probably looking at August before we have any kind of results back. What's your schedule in August?
Would August 12th work, Your Honor? I'll be here that day.
Yes. Okay, August the 12th will be the next hearing for a pretrial. 10 o'clock.
Thank you, Your Honor.
You're welcome.
What's the next day, I'm sorry?
August 12th.
State of Ohio versus Tammy Thompson. Case number CRA 24334. Your Honor, this is a preliminary hearing for Mr. Smith.
Okay.
What's this?
Judge, to speak with Mr. Hill, I think there's going to be a reduction or a request for reduction to a misdemeanor of domestic violence. Jazz was not here, but I understand she's spoken with the alleged victim. He's okay with that. Part of the deal was you've still got a key to his apartment or house. She will return that. They're no longer together. and there's not
There was
anticipation.
some question about her getting some of her stuff out before. Did that happen, or?
No, it was all right, everything's all right.
They're working on something, I'm not sure the details, but you okay with that?
It looks like you filled a statement out. And it looks like you did fill a statement out to drop all the charges. Is that correct?
We're going to produce it to you.
Reduce it.
So, first degree, or?
Yes, Your Honor.
Okay, so we'll amend the domestic from an F4 to an M1.
Yes, Judge, and we leave the amount of incarceration up to the court. Mr. Hill's not opposed to holding over her head, suspend. How did you go?
That's right, Your Honor. We would request a 30-day suspended jail sentence. And in order that she get the key back, I don't know the specifics of how we'll do that, whether she has the key now or...
She has the key with you now? She could drop it off at the prosecutor's office. Just put an envelope with your name on it. I'll see if she's not get back to him. That'll work.
So there's a change of plea also?
Yes, Judge, yeah, we leave, she spent, I guess, the 1 day in jail when she was booked in. That's all the jail credit she has, but she assures me they've broken up. She's not going to see this fellow again.
All right, do you agree with what your attorney has represented to the court, Ms. Thompson?
Yes.
Do you have a statement you want to make to the court before sentencing?
No.
Okay. Is there any restitution? The affidavit says there were some broken items in the house.
He did not request any restitution.
Okay.
Just knickknacks and stuff.
I'll impose a $100 fine, court costs. Uh, 10 days in jail, non-suspended credit for 1 day she served. Is there a no contact order or anything like that?
No, Your Honor.
Okay.
He's here.
Take that part out. Yes. Okay, I'll make it a level 5 probation for 2 years. Review hearing December 23rd. Please to see Mr.
December 23rd at 9 o'clock.
Major before we leave, before she leaves.
Yes, I'll direct her there, Judge. 9 o'clock.
This is Mr. May.
We'll get all this in.
Yeah, he says he wants her to get her stuff out, and he doesn't want to have any more contact with her. Do you want a protection order?
No.
Is there a third party?
I had down Jamie, was the name of somebody who was going to help get stuff out.
Yeah.
Is that still okay?
You know who Jamie is?
She's fine with Jamie. I'm not.
Jamie Nunley. What is
He's
it,
okay with
Dudley?
that too?
Dudley?
Oh, I can't remember.
No.
Dudling, D-U-D-D-L-I-N-G, Dudling.
Oh, Dunning.
Do we have an agreement then that that person can come get her stuff? Okay. Then shaking his head yes. All right, review hearing December 23rd, 9 o'clock.
All right, thank you.
Thank you, sir.
Thank you, Judge.
You're welcome.
State of Ohio versus Jessica Coiman, case number CRB 24396.
Ma'am, are you Jessica Coiman?
Yes, sir.
Ms. Coiman, it's alleged on June 21st, you caused inconvenience, annoyance, or alarm to others by fighting, threatening to do harm, being violent or turbulent.
I was walking on the side of the road.
This is a minor misdemeanor, disorderly conduct, maximum penalty is $150 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights? How do you plead to the charge?
Well, I mean, I was walking on the side of the road, I got arrested, so,
Well, were you being violent or turbulent or fighting or causing inconvenience to anyone?
maybe inconvenience with drivers. There's nowhere to walk hardly on the side of the road there. I was,
Well, that's not disorderly conduct.
I mean, that's what I didn't understand either. I didn't really understand why I got arrested.
Okay.
I think they said they were afraid for my safety, and I didn't come up with anybody. I stopped to be able to breathe for a moment, and one of the neighbors asked me if I was okay. I did not proceed onto their property. I stayed on the side, said no trespassing. They offered me a drink so they could get me right across the bridge. Next thing I know, here comes the sheriffs. Saying they'll give me some help for taking me to jail. I had nothing on me but my mother's obituary. I had no illicit drugs on me, nothing. So, I mean, I don't really know what.
I don't know either, because I wasn't there. What's the state say?
Well, Your Honor, the allegation is that Ms. Coyman was in somebody's driveway sitting and that she had used heroin. Apparently she was in a state of having just used drugs, and they basically didn't know what to do with her. So I think that just from looking at this, that looks like Ms. Coyman's issues are way bigger than a minor misdemeanor can help with. And I don't think she caused any lasting harm to anybody.
If I could speak for myself, sir, I was actually in withdrawal at the time. I had not just used.
So she was in withdrawals at the time, which is probably maybe even worse, because the person going through withdrawals typically not in a very good.
Like I said, I wasn't bothering anybody. I was asked if I was okay by somebody.
Well, do you want some help for your drug use?
I mean, I'm going to get help for that in West Virginia. I mean, I take mental health medicines. I need to get back to my doctor over there.
I've got you living in Chesapeake, is that right?
I live in Chesapeake, yes, but mostly go to Huntington. I mean, I'm mostly in Huntington. That's where I was going when I was walking.
Do you have a Medicaid card?
Whenever I actually tried to get into treatment earlier that day before I got arrested in West Virginia, and they told me I needed to contact the DHHR, that I missed a review hearing.
Over in Capitol County?
Yes, sir.
Okay, do you have West Virginia Medicaid?
I did at the time, yes. So, I mean, I just need to contact DHHR, and I'm pretty sure they'll give it right back to me.
So you don't have an Ohio?
No, I've never had one.
You've always had West Virginia?
Yes.
Okay. I can get you in a facility probably if you need help. If you're doing heroin, you need help. Do you want to get in a facility for a treatment?
I mean, I haven't used since the day before I got arrested.
Well, but that wasn't that long ago.
I mean, I'm past the worst of it, I'm pretty sure. I mean, I pretty much dealt with it on and off my entire life.
Who do you live with in Chesapeake on County Road 31?
I live with William Lynch, the man who got me bailed out. He got a bail bondsman to get me out because he was afraid for my safety too.
Okay.
I mean, the only time I met him in Ohio was whenever I'm at his home sleeping. He works in West Virginia. I have a storage unit in West Virginia. I've had most of my employment in West Virginia. And that's what I was doing whenever I was...
You're not working now, I think.
No, not right now.
I probably can get you in a place where you'll have a place to sleep, food to eat, and help with getting off of heroin. And you won't have to depend on this gentleman.
I mean,
Are you interested in that?
I mean, I'd like to, it's not that I appreciate you offering to help me. It's just, I know what I need to do to get help. I just want to get my Social Security medical card back, get on my mental health meds,
Where do you go for that?
OVP.
Okay, we've
To
got
really
somebody
help.
from OVP here today. Do you want to talk to them further?
If they can get me on my mental health meds. I mean, I don't want anything to do with heroin or any of that anymore. I just want my Zoloft and my Abilify.
You don't want him, what you said, I didn't understand what you said. I don't want any more to do with what?
With any illicit drugs,
Okay, well, that's good, because you know what? What's out on the street is really dangerous right now.
yeah.
I mean, you say you do heroin, I don't see that much heroin anymore. What I see is fentanyl and methamphetamine.
Well, opiates.
Yeah. Fentanyl's taking people out, though. If you get stuff off the street, you're probably getting fentanyl. Why don't you talk to Brianna from OVP, and then we'll come back and decide if we're going to do anything further. She can talk to you about getting you some help. Okay? She's right at the back door. Go talk to her and then come back.
Okay. Thank you.
Okay, we're going to go to jail for some teleconference hearings.
State of Ohio versus Scott Bryant at Lawrence County Jail, case number CRB 24394, and Tanner Click is on deck.
Sir, are you Scott Bryant? Can you hear me? All right, apparently you can. Scott Bryant? Okay, that's me.
Yeah, I can hear, barely hear you. Yeah, thank you.
All right, sir, are you Scott Bryant?
Yes.
Okay.
Yes, sir.
All right, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. That's where your case is filed.
Okay.
So you are appearing in the court by teleconference, and your image and what you say is all being recorded. You have a right to remain silent. You don't have to say anything. If you do say things, it's going down on the record. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail. You have a right to make the state prove this charge beyond a reasonable doubt. You understand those things?
Yes. Yes, sir.
You're charged with domestic violence. The state's filed a complaint against you alleging that on June 23rd, 2024, in Fayette Township, you knowingly caused or tried to cause physical harm to Jack Lawless, and that Jack is either a member of your family or a member of your household. So that's why it's domestic violence. Carries a maximum penalty of 6 months in jail and $1,000 fine. Do you understand the charge?
Yes, I do.
How do you wish to plead to this charge?
Guilty.
If you enter a guilty plea, you're admitting it's true, and by doing that, you waive the right to have a trial and to have a lawyer. Do you understand that?
Yes.
Is that what you want to do?
Will it be on video or?
That I don't know if there's any video or not. If you're not sure of what to do, you should enter a not guilty plea.
Not guilty plea, I'd rather do that.
Okay, I'll enter a not guilty plea for you. Do you have the money to hire a lawyer?
Okay.
Do you have the money to hire a lawyer?
Yeah. Yeah.
You do have money with which to hire a lawyer?
Yes.
Do you have a job?
Not right now. No. I'm on Social Security.
Is that your only income is Social Security?
Yes.
Okay, I'm going to go ahead and appoint a lawyer for you.
Okay.
Mr. Thompson, I'll appoint you to represent Mr. Bryant. So, appointed you a lawyer. He's been here in the courtroom, so he's heard the arraignment. He knows what the charges are.
Yes.
Okay. What's the state's position on the bond? Does Jack Wallace live with you, or you live with Jack Wallace?
Yes, sir.
Is that a relative?
He's my stepdad.
Okay. Is Jack Wallace here or some family member for Mr. Bryant here today?
Could you repeat the question, please?
I was asking people here if there was anybody that was your family member here today. It doesn't look like there is. What's the state's position on bond for Mr. Bryant?
Well, the state would not be opposed to an OR bond, but we want to make sure that there's no contact until we can have an opportunity to speak with Mr. Lawless.
Can you try to do that today?
Yes, but we would ask for the protection order. Well, if we wanted to recall the case, we could
I
try.
think let's recall it. I think our detector might be some issues here. So I'd like for you, Mr. Thompson, to call down, talk to Mr. Bryant, and then the whole issue, whether there is a protection order requested, and if he has another place to go to. So what's going to happen, Mr. Bryant, your lawyer's going to call and talk to you off the record so we're not all listening in to your conversation, and then after that happens, we'll come back and I'll finalize the conditions of bond, where you're going to be staying, and hopefully get you out of jail someplace. Mr. Thompson, you want to take the court's file and let the bailiff know when you're ready to recall it?
State of Ohio versus Tanner Click at the Lawrence County Jail, case number CRV 24391, and Trevor Click is on deck.
Sir, are you Tanner Click?
Yes.
Mr. Click, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is where your hearing is being held today by teleconference. Your image and what you say is all going on the record, so if you make a statement, it can be used against you. You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed. If you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. You understand those rights?
Yes.
You're charged with menacing. It's alleged that on June 24th in Fayette Township, you knowingly caused Olivia Mae Craft to believe you would cause physical harm to her person or property. That's a menacing charge, maximum penalty 30 days in jail, $250 fine. You understand the charge?
Not guilty.
I'll enter a not guilty plea for you. Do you have a job?
What was that?
You have a job. Do you work?
No.
I'm going to appoint Mr. Smith to represent you, Roger Smith.
Yeah.
Not guilty plea is entered. Your lawyer's here in the courtroom.
Yes. May I speak on the matter?
No, not at this time. I'm going to call you at the jail and talk to you just a minute, okay?
Okay.
That was your lawyer talking. He advised you not to speak because it's on the record. It could be used against you, what he said.
She charged at me with.
Okay, don't talk. I'm going to talk to you in just a minute. I'll call you. But everybody can hear what you're saying, so I need you to just be quiet for just a few more minutes.
No, I don't believe it is. Trent?
There's another.
That's what I was asking, there's a crossfire, there's another.
He was arrested on a warrant.
Oh, okay.
Okay, so in this matter, Your Honor, the officer's narrative indicates that Mr. Click's brother and Mr. Click's brother's girlfriend, who's the victim, Olivia, were having a problem with Mr. Tanner Click in the home, and they indicate that he has mental health issues, diagnosed with schizophrenia.
Hang on.
And that he had a knife and had made threats, and they were concerned about him because of his mental health issues. That's what's alleged. So as far as what should happen at this point, I guess it would be a good idea to find out what the extent of those mental health issues are too, particularly with respect to the fact that there was a knife involved. And I don't know whether this other case involving Trent Click has anything to do with this, although,
Your Honor, the other case was a failure to appear,
okay.
a failure to appear on a review.
So it doesn't have anything directly to do with this.
If we could recall this, Judge, let me call down and just get a better feel for the case. And
All right, Mr. Click, your
Thank you.
lawyer, Mr. Smith's going to call down, talk to you, and I'll set bond after that happens.
Thanks, Judge.
Hang on, go ahead.
Just wait and talk to your lawyer, and what you say to him is privileged, it won't be on the record. What you say here in open court is on the record, it's not privileged.
Okay, so do I come back to this today?
You will come back after you talk to your lawyer.
If you have the jail, just keep you out. I'm going to call in the next 30 seconds.
State of Ohio versus Trevor L. Click, case number CRB 23677, and Charles Frick is on deck.
So are you Trevor Click?
Yes, sir.
All right, Mr. Click, it's alleged that you missed a review hearing June 3rd.
Yeah, I didn't.
Okay, so hold on, June 3rd of this year, and it was on a theft offense. And I guess that's why you got picked up on the warrant. It was, looks like it was a Walmart theft offense. You did your community service, it's alleged, but you didn't pay your fine and you didn't come to your review hearing, so you got a warrant issued.
Yeah, I wasn't aware of that. I wasn't aware of my court date or anything. I thought after I finished my community service, it was good.
Okay. You still live at Private Drive 3952?
No, that's not my address.
Where do you live now?
35 Township Road, 1276. That's my actual address.
35 Township Road what?
1276.
And what's the post office?
Huh?
What post office is that?
45680.
Is that South Point then?
Yeah, that's not one.
And you've been in jail since yesterday?
Yeah.
Okay, you still have fines and court costs you were supposed to pay on your prior case. You understand that?
I thought I worked off the fines for the community service.
No,
That's what I asked for.
you had community service order to do 5 days. You did the 5 days. You can work off your fines, but you got to do extra days to work off your fines. You didn't do that.
Oh, I thought I did do that. That's a misunderstanding.
Okay, I'm going to find you in contempt for not coming to court previously as ordered. I'll send you to time served. I'll give you a new review hearing date. So you guys start working. You can work off your fine, or you can pay it, or you can do some of both. Okay, do you understand that?
I understand.
And I'm going to set your next hearing for August the 2nd. So we'll make it easy to remember. The first Friday in August, you have to come to court unless you.
I will be there.
Unless you finished everything, you paid it off, you don't have to come, but if you still owe money, you gotta show up August 2nd, 9 a.m., or you'll get a warrant again.
Okay, I understand. I will be there this time.
Okay, so you'll get out of jail, assuming there's no other holder on you from any other court.
Oh, is that?
If you don't have a holder from another court, you're gonna get out of jail here once we get the paperwork completed.
All right, I appreciate it.
Okay, you're welcome, that's all.
State of Ohio versus Charles Frick, case number TRC 24-1281 A and B, and CRA 24-390. Justin Hargis is on deck.
Sir, are you Charles Frick?
Yes, sir.
Mr. Frick, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. Your hearing is taking place here in the courtroom with your image showing on a monitor. What you say is being recorded. You have a right to remain silent. You don't have to say anything. If you do make statements, it can be used against you. You have a right to have an attorney, to have one appointed. You can't afford one. You have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Do you understand these things?
Yes, sir.
You've got two issues. You've got charges here in Ohio, and it's alleged there's charges against you in Georgia at Bartow County. The charge here, 24-1281. And it looks like that's A and B. Alleges that on June 21st at 7:13 p.m. in Union Township, you were driving a vehicle under the influence of alcohol or drugs. It's alleged this will be your first conviction if you are convicted. And it's alleged also that you refused to take tests. The maximum penalty for this is 6 months in jail, a $1,075 fine, and a 3-year license suspension. That's the most the court can impose if you're found guilty. There is a minimum, so the least the court can give you if you're found guilty is 3 days in a treatment program, a 6-month license suspension, and $375 fine. That's the minimum. You're also charged with driving outside your lane, left to center. That's a minor misdemeanor. Maximum penalty is $150 fine. Do you understand those charges, Mr. Frick?
Yes, sir.
The charge in Georgia alleges that in Bartow County, Georgia, this is from the Bartow County Sheriff's Office, which is in Cartersville, Georgia, that you moved outside the jurisdiction of the court without permission from your supervising probation officer, and that you're on probation for possession of methamphetamine, possession of drugs, and violation of motor vehicle laws. So they issued a warrant for you, and they want you to be sent to Georgia on those matters. So that's pending also. So let's go back to the current charges here in Ohio. The driving under the influence and left to center. How do you plead to those charges?
Guilty.
Guilty means you're admitting they're true. Do you understand that?
Yes, sir.
Now, on the extradition matter, you have a right to have an attorney on that, to have one appointed if you wish, to have an extradition hearing. And that would be a hearing to decide if there's a good cause to send you to Georgia on this warrant. It wouldn't be whether you did or didn't do the violations down there, just whether the court should send you to Georgia.
Well, I mean, briefly, Your Honor, I was sent to Georgia prison. I served my time, and I was on parole. And I was in my driveway in Ohio, came and brought me up here and sent me to Star. And my probation officer told me that everything was resolved down there, and therefore not to worry about it. So I came up here, I went to Lawrence Recovery Program. I just graduated from there, and it's going fine up until this little episode that I just did to myself.
Okay, well, do you want to have a lawyer appointed then?
Well, obviously I need someone to help me figure it out because there's been no warrant issued up to prior to, so I don't know what's.
Maybe it's a holdover. Maybe they issued it before and just didn't withdraw. So that's a possibility. Who represented you in common? Sounds like you had something in common police court, right?
Please?
You had something in common police court here before to get sent to Star?
No, it was Claremont County. I was on probation in Claremont County.
So it wasn't Lawrence County that sent you to Star, it was Claremont County.
Yeah, right. I've never been in trouble in Lawrence County, sir.
Okay, well, I was trying to find out if you had a lawyer here previously that was familiar with your case, so you don't.
No, sir. No, sir, not at all.
All right, Mr. Morford, I'll appoint you to represent him probably should make it for everything. He had entered a plea on the OVI, but I'll go ahead and appoint you if you want to withdraw it, since it was uncounseled, I'll allow that. And he has a warrant out of Georgia. And I've got a Huntington, West Virginia address for you, Mr. Pruitt.
Yes, sir.
One 137 26th Street.
327, 26th Street.
327.
Yes, sir.
26th Street.
Yes, sir. Now they're trying to also tell me that my truck is under a court order, that I can't have my girlfriend to go get my truck. Otherwise, everything that I own is in my truck. So nothing can be done to help my financial situation here. I have a job. I work at the sanctuary here in town, and also, I mean, I don't know if you can take my word. I don't know how this could work. If I could get a 24-hour leave to go handle my personal affairs and come back with an ankle line, I don't know. But is there any way you could possibly allow me to do that, to go get my personal affairs in order?
What's the state's position on bond?
What does Georgia request? Does it indicate?
Yeah, they want him to return there on some sort of parole or probation violation.
But I mean, as far as the bond,
There's nothing on here about a bond.
we know what day Mr. Frick was arrested?
Yes. June 21st.
So today's the third day. Just thinking about time served, I know he allowed him to withdraw his guilty plea, but if he were to plead to the OVI, and we would recommend 3 days in jail, of which he's on his third day, and I believe it's a first offense, and then we would be okay with him being released on an OR bond and allow him to go back to Georgia and handle his situation there.
Which I would certainly do.
I don't know that I would go along with that after reading the facts of the case. I don't think I would go along with that. So there's going to have to be a bond. And he's relapsed. He was in recovery. He's relapsed. And he was all over the road, almost striking vehicles. And I'll let you go all down and talk to him, but there's going to need to be a bond here.
Well, I'm more concerned about the OVI. And it just happened.
State of Ohio versus Justin R. Hargis, case number CRB 24393. Kathy Lewis is on deck.
All right, sir, you're Justin Hargis.
Yes, sir.
I'm Judge Capler of the Lawrence County Municipal Court. Your charges were faxed to the court this morning at 10 a.m. an hour ago, basically. It's another disorderly conduct, minor misdemeanor.
Yes, sir.
You're charged with disorderly conduct that at Fayette Township on June 21st, you recklessly caused inconvenience, annoyance, or alarm to others by engaging in fighting, threatening harm, being violent, or turbulent. It's a minor misdemeanor. Maximum penalty is $150 fine. You understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead?
Guilty.
Guilty means you admit it's true, and you waive your rights to have a trial and have a lawyer.
Yes, sir.
Looks like you got some sort of argument at Walmart.
Yes, sir, it ended at Walmart.
And it's saying in the affidavit that you've got outstanding warrants through Scioto County and other places, but I got none of them here.
Cole Grove and Rockville, actually.
Okay. All right, $50 fine, court costs.
Thank you, Judge.
You're welcome.
State of Ohio versus Kathy Lewis, case number CRB 18414, and Kimberly McCann is on that.
And Mr. Morford represents Kathy Lewis. Set for pre-trial today. Is she applied to go to treatment or?
She is, we're supposed to pick her up today.
Okay.
This is the young lady that we had in Ironton Municipal Court the other day, Your Honor, and I had asked about the possibility of her going to treatment, and we just determined probably it's best for her to appear here first. So I don't, I think she's here on review matters.
Yeah, failure to appear for review. And she's agreeable to going into that?
Yes.
And our municipals were there?
Yes, we did an assessment on her last week.
Okay. And remind me, is that hometown?
Hometown recovery, yes.
Okay, I'm going to release you to hometown recovery. And set for next review hearing. July 12th.
Thank you.
You are.
State of Ohio versus Kimberly McCann, at Lawrence County Jail, case number CRB 24395 A and B. And Kayla Sechrist is on deck.
Ma'am, are you Kimberly McCann?
Yes.
I'm Judge Kapler at the Lawrence County Municipal Court. This is your arraignment. You have a right to remain silent. You don't have to say anything. But if you do say things, it's on the record. It can be used against you. You've got two charges, violation of a protection order and disorderly conduct. The violation of protection order alleges that at Fayette Township on June 21st, you recklessly violated a protection order. That's a first degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. And that you also engaged in disorderly conduct. That's a minor misdemeanor, maximum penalty is $150 fine. Do you understand these charges?
Yes.
Do you understand your rights?
Yes.
How do you plead with these charges?
Not guilty.
You want a lawyer appointed to represent you?
Please.
Do you have a job?
I did, sir.
Where did you work?
General manager of Cheetah Clean.
What's the name of it?
Cheetah Clean, general manager.
Were you paid by the hour?
I was paid salary,
What's your salary? I have to determine your gross annual income.
55 a year.
You're making $55,000 a year?
I was.
You're not working any longer?
Probably not now, no, sir.
Oh, just because of these charges?
Yes, sir, because I was in jail.
Okay. Well, what if we get you out of jail, maybe you can go back to work?
I hope so.
Well, if you're making $55,000, you're not gonna get a court-appointed lawyer because you make too much money.
Right, I understand.
You got a Proctorville address?
No, sir, that's not, the address is not correct on my paperwork either.
County Road 107, you never lived there?
I lived there, but it's been, gosh, years and years ago, sir.
What's your current address?
I'm in Bowling Green, Kentucky.
Okay. Do you have an actual street address in Bowling Green?
175 Orange Court. Bowling Green, Kentucky. 42106.
Give me the zip again.
42101.
Can you post a bond?
I don't even know what the bond is, sir.
Well, I haven't said it yet. But if I said a bond, you think you could post it?
I don't know, I got one son, I got one kid in Wyoming, I got one out of the country, and I got one that works night shift at the hospital. I don't know if I can or if I can't. I might just stay here.
State position on bond?
Your Honor, I was wondering previously why there was a 3-page report on Mr. Hargis, which was a minor misdemeanor, disorderly conduct. It's a, yeah, and it appears that Mr. Hargis is the protected party on the protection order that's alleged to have been violated. And it appears even that that protection order is from another state, if I'm reading all this correctly. We'd ask for a small cash surety bond, $1,000.
Okay, ma'am, if I set your bond at $1,000, that usually means you have to pay a bail bond. You can either post $1,000. If you do that and you come to court at the conclusion of your case, you will get the whole $1,000 back. It's just to guarantee your appearance. If you can't post $1,000, you can hire a bail bondsman. They're responsible for the $1,000. You got to pay them a fee. Usually it's $150. But then if you don't come to court, they're going to be hunting you down because they don't want to pay the $1,000 to the court. Can you, post a $1,000 bond one way or the other?
No, sir, that's what it already was, and like I said, I have a kid that's out of state working in Wyoming, I have a kid that's out of the country right now, and I have another daughter that's a registered nurse that works King's daughter's night shift, and there's no way I can get a hold of all three of them. I try to find her out of our now, and there's just no way possible, so I'll be here until the next 4 days, I guess.
I guess what I'd want to know, I believe maybe that Ms. McCann is from this area originally.
Originally, yes, sir.
And I don't know why she was here other than this situation that is described in the...
I came here just to get my car started. That's the only reason why I'm in town, just to
If
get
you
all
talk
that, get my car.
if we get a bail bondsman to talk to you, usually just about everybody, including bail bondsmen, are carrying cell phones. And they can call your kids. So you're telling me you make $55,000 a year, you got a kid working at a hospital, a kid working in Wyoming, a kid doing something else, and between all four of you, you can't come up with $150?
Oh, I'm not saying I don't have the money. I have the money. It's just getting them to get to it is what I'm saying. When
We can have the bail bondsman get in touch with you, and he can call these other folks and arrange to get your bond together. Okay, so I'm going to set your bond at $1,000, cash or surety. And you do want a bail bondsman to contact you, correct?
Please.
All right, so, and it sounds to me like you're going to be able to post bond. You should be able to post bond.
Yes, sir.
I will not appoint a lawyer for you because you make too much money.
Yes, sir.
When would you like to come? Do you want to come back sooner or later for your next hearing date? Do you want to go back to Bowling Green for a while, or do you want to come to court as soon as possible?
I would like to go back to Bowling Green and then, because I only get paid twice a month. I get paid semi-monthly, so I need to make sure I have money to funds to be able to travel back and forth.
Okay.
On top of paying my car payment, insurance and all that stuff too as well. So if I could get it out a little further and then come back, that'd be great.
Let's make it July 22nd.
Yes, sir.
July 22nd, so that's the fourth Monday in July. And you're sure you can post, I don't want you sitting in jail that long.
I'm gonna try, like I said, whenever, I know I can't go into details, but whenever my car was taken, my credit card, my banks, everything that I owned was also taken as well, so that's what I'm saying. I'm gonna try, if not, then I'll be sending it to the bar.
We'll let Mr. Sowers will contact you. If you can't post a bond, you'll let the court know, and I can move your hearing date up. But I'm gonna assume you get out, you gotta be here July 22nd at 10 o'clock unless your lawyer makes arrangements for a different date.
Yes, sir.
And apparently there's a protection order for you to stay away from Mr. Hargis, so I'm gonna remind you of that.
Yes, sir.
Okay, that's all.
Thank you, sir.
You are.
State of Ohio versus Kayla M. Sechrist, case number CRB 24373, CRA 24389, and Hunter Tooley is on deck.
Okay, this is on the docket for sentencing, and, well, she has a holder too. Okay, Ms. Sechrist, you're here, and I got a place lined up for you to go, but there's a problem. She's got a, looks to me like a warrant out of Carroll County Circuit Court. The order is saying, regarding May 28, 2024 hearing and arrest order. Defendant, having failed to appear for this hearing, is therefore ordered the bond be revoked and arrest warrant be issued for the accused and delivered to the sheriff. Kayla Sechrist is the defendant. So, here's what I think we need to do. Mr. Smith, I'm going to appoint you to represent Kayla.
Yes, sir.
She had pled here, and I'll let you withdraw that, to a Walmart theft offense.
Yes, sir.
Last week. I delayed sentencing because there was, she admitted that she needs some help. Hillcrest was here to take her today, but she has a warrant out of Cabell County.
Okay.
Now, maybe they'll agree that she go there.
I will call and, yeah, I'll find out.
I don't know if we can get that done today.
I'll try.
Looks like,
You know which judge, which court?
yeah, let's see. Well, they only gave me one page of the order, and it doesn't have the signature page. But it's Ray Nolan. Is he prosecuting or defending him?
He's defending, he's still
Okay,
defending.
he was his name is on here, so he must have been her lawyer.
I've got Ray's cell number, I can call him and get information.
Al Ferguson's the judge.
Okay.
I got the arrest warrant, has his name on it. So, we're gonna try to work on this today.
If you don't mind if we could recall it, I'll be glad
The
to.
gentleman from Hillcrest is Richie.
I'm Harmony Ridge, yeah.
Harmony Ridge, okay.
Okay.
But I got your name right.
You did.
So that's a big plus, because I don't.
I thought Hillcrest was a landscape, and I wasn't sure.
Harmony Ridge, I don't know how I got Hillcrest. But he was here willing to take Kayla, but I can't go until we get this warrant from Cabell County cleaned up. So Kayla, we'll trying to get you into treatment, but you keep creating problems when you don't show up in court. They're saying you didn't show up in Cabell County, so guess what? You got a warrant when you didn't show up. which means I can't release you till that's clear. Okay, on the last one. So she already, she mentioned
State of Ohio versus Hunter E. Tooley, case number CRB 24385 A and B of the Lawrence County Jail. Scott Bryant is on deck.
Hunter Tooley is represented by Mr. Morford. He's here for a pretrial.
Judge, I think we're looking at placing him into treatment today after he had a little chance to think about the treatment he's been giving his grandmother and other things.
Who's willing to take him?
Okay.
Hometown can take him? You need to do an assessment first?
Yeah,
or-
can I do an assessment first and then come back?
I didn't hear the last thing you said.
Can I do an assessment on him first?
Yes.
And then just recall him?
You might want to talk to his grandmother. She's here, she's the victim, a repeated victim, and as I understand it, a witness to some of his drug use.
Yes, sir.
So let's pursue that, and then we'll recall it later. And he needs to go inpatient. Inpatient. It gets him out of grandma's hair and away from her for a while.
Thank you, Judge.
The case will be recalled.
State of Ohio versus Scott Bryant, case number CRB 24394. Tanner Cliff is on deck.
All right, Mr. Thompson is representing Mr. Bryant. You've had a chance to talk with him.
We'd ask for an OR bond and that he be released to his sister.
His sister is Amy Mettings.
Amy Bryant Mettings.
Is that agreeable?
Yes, Your Honor, we attempted to contact Mr. Lawless, but they didn't give us a phone number, so we haven't been able to.
Okay. All right, Mr. Bryant, I'm going to let you out on a signature bond of $1,000 with an order that you stay away from your stepfather, Jack Lawless. You go to your sister's house.
And that he call me, Your Honor, please.
Yeah, so.
He's got my number. He couldn't remember his.
Okay, you got to call your lawyer. And when do you want to come back, Mr. Thompson, for the next hearing? We're looking at
The 8th?
Okay. July the 8th, your next hearing. In court in Chesapeake at 10 o'clock. You know where the court is in Chesapeake?
Thank you.
Do you know where the court is in Chesapeake where you have to come to?
Oh, yeah.
Okay. You got to be here July the 8th. So that would be not next Monday, but the Monday after that.
Okay.
And stay away from Jackson.
We're going to have him
more
sign.
We'll have to sign protection.
Okay, we'll send down an order, protection order for you to sign. Okay, we got some recalls at the jail that are not ready.
State of Ohio versus Kim Dixie, here at Lawrence County Court, Lawrence County District Court, case number CRB 24161.
This is Mr. Thompson's case. My notes were this would be a dismissal of the restitution and cost of pay.
He's got $250 to pay today. He's gonna need a little bit of time.
Well, that's pretty close, isn't it? What is the, oh, there's more than one check there. Okay.
Total's $411.32.
Okay. All right, we'll see the clerk make a payment on it, and then when does he think he can have the rest of it?
Within the middle of next month?
You sure about that?
Yeah, I'm positive of that.
July 22nd?
Thank you.
Yes.
July 22nd will be the next hearing for a pretrial, 10 o'clock.
And if I get everything early, can I go ahead and pay, or
Yes, you can come in and pay it.
just come here?
Does that include the court cost, with the number that we were given?
No, that was just the restitution.
Plus court cost.
Okay, so how much would that be?
So 130 or
150.
150.
Oh, yeah.
Court costs are 150 now. 120, 125 plus the 25 assigned counsel.
Yes.
So 150 total.
State of Ohio versus Donald Knight, here at the court, case number TRC 24752.
This is set for a pretrial today. It's Mr. Thompson's case.
Your Honor, this is a urine test, and it was being screened both for alcohol in the urine and drugs in the urine. And so far, we have the alcohol in the urine test back, and it would be below the per se. The drug part is still pending. What I'd like to do, if possible, is to go ahead and inquire about that. And we have somebody, asked somebody to do that earlier today, didn't we?
You got missing.
If I can inquire about it, if Mr. Knight wants to have an answer today, then we may have the answer today.
You want to recall it then, Mr. Thompson?
We're good to just continue it for another.
All right. That's okay too. Now, the time runs on July the 7th, so we'd have to come back maybe next week.
The 8th.
Well, is there a time waiver till then?
They're looking for the results.
Okay, well, I'm not going to say at the 8th, the time runs July 2nd.
No, it's 10th.
No, the 7th is when it runs.
Oh, it's the 7th.
So we'd have to come back next week.
Well, July 1st, you'd have to set it for trial immediately.
Yeah.
Like the 5th. All right, July 1st will be the next hearing for pretrial. 10 o'clock.
State of Ohio versus Heather M. Robinson, case number CRB 24281, A and B.
Mr. Thompson's case set for pretrial.
And Ms. Robinson is in Cincinnati with transportation problems. She was supposed to be on Zoom.
I don't see her.
Yes. So we're coming back on the 1st. And give her 7 days and warrant.
She has 7 days to appear before the warrant will issue.
State of Ohio versus Kimberly R. Yates, case number CRB 2429.
Kimberly Yates, this is Mr. Thompson's case. My notes were there would be a dismissal if also restitution.
And I believe everything's been paid.
Looks like there's been some payments.
The restitution, I believe, was paid, and this was the court costs.
Well, there's been more than the court costs paid. It looks like there's court costs showing paid.
She paid the restitution.
May 24th, there was, a little bit more than the restitution amount. Then there was another payment, June 21st. So it looks like that took care of the cost. So the case will be dismissed.
Thank you very much.
State of Ohio versus Cameron Spitzer. Case number TRC 231161, A and B.
This is Mr. McCown's case now.
Yes, Your Honor.
Set for pretrial.
That's correct, Your Honor. Your Honor, we previously had a suppression hearing on this matter. It's my understanding that Mr. Spitzer, as a result of that hearing, would like to change his plea to a plea of no contest with a stipulation of finding of guilt.
Okay, is that correct, Mr. Spitzer?
Yes.
Is there a recommended sentence?
I believe it was going to be the minimum, Your Honor.
Your Honor, it's a first offense. The test score was .142. So really, other than that fact, there's really nothing that aggravates this situation. So we'd ask for the mandatory minimums on this.
All right, Mr. Spitzer, you have the right to make a statement to the court if you wish before sentencing. You don't have to. Do you have any statement you wish to make?
No.
I'll impose a $375 fine, court costs, 6-month license suspension, which is actually up now. So you just need to contact the DMV about getting reinstated. 20 days in jail suspended, 5 days community service, 2 years of level 4 probation. Attend the driver intervention program. Review hearing December 23rd of this year. If you finish everything before then, you don't have to appear. That's at 9 a.m. It's a hearing to ensure that you completed what you're ordered to do. He's to see Mr. Major before he leaves, and is there a representative of the? Okay. We need 2 people. Probation and the dip school. See those representatives in for you guys.
State of Ohio versus Ryan T. Evans, case number CRB 23723, TRC 231777, A and B.
This is also Mr. McCown's case for motion here.
Your Honor, actually, after substantial negotiations previously, we had set up for, I think, a change of plea. Previously, it's been continued multiple times, I think just due to the scheduling of court and prosecutor. So, at this time, Your Honor, it's my understanding that Mr. Evans would enter a no contest plea with a stipulation of finding of guilt. As to the OVI, the other matters would be dismissed, is my understanding, by the state of Ohio, and there'd be a recommended minimum sentence on the OVI. I believe he has already completed his dip school. I don't know if that's in the court file or not.
It is in the court file. It is.
And Your Honor, upon the plea of the OBI, we would move to not only there's a child endangering, there was a young person in the car, and also the marked lanes, we would nolly those 2.
And Mr. Evans, you have a right to make a statement to the court if you wish. You're not required to. Do you have anything you want to say?
No, Your Honor.
I'll impose a $375 fine, costs, 6-month license suspension. Again, that's included now, so you still need to reinstate with the B&B. It doesn't automatically go back. You have to contact them and pay reinstate. 5 days of community service. He's completed the driver intervention program. The review hearing will be December 23rd of this year at 9 a.m. Complete everything. You don't have to come back for that hearing. Just confirm with your probation officer you are completed. The remaining charges are dismissed.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Tanner Click at the Lawrence County Jail, case number CRB 24391. Kayla Sechrist is on deck.
Mr. Smith's case,
Yes, Judge, I called down and spoke to my client.
he's on the screen now.
Yeah, okay, good. He treats at Shawnee. He's got an appointment Wednesday, but as I understand it, it's for his type 1 diabetes, not his mental health he's engaging in. And it sounds like he's talking to me. He's not want to see this doctor anymore at Shawnee, so I don't know what as far as bond. He says he can live with his brother and girlfriend. His brother and brother's girlfriend live elsewhere, so there shouldn't be any contact. It's an M4. He's not had his insulin since he's been arrested, I guess, 10 hours ago. It's type 1, which is obviously very serious. I'd like to see some type of OR bond. He stays with mom, so he can make his appointment Wednesday at Shawnee.
Sure.
Well, I don't know who all lives in that household. We would have to make sure at this point, and, you know,
That's what he represented. You
It's
just
a
live with your
serious-
mom there, right?
it's a serious situation as far as the allegations involving a knife and whatnot. So,
I understand that, but also said the brother in the statement says, I just want him to get help, which I don't think sitting in jail not taking his medicine is what his
I
brother
agree
did.
with that.
Can you confirm, Tanner, that you live with your mom, your brother does not live there?
Brother's there at the jail, too, was recently, just
That's
recently.
right, yes.
Got released.
When your brother's not in jail, he lives elsewhere, correct, with his girlfriend Olivia?
Now, the individual that's involved in this, who is his brother, his name is Trent.
Trevor. Trevor Tanner
Well, this is
Trent.
Trent. And this, so there could be another person.
Who lives with your mom? Who all lives in that house?
My mom, me, and Trent, not Trevor. Not Trevor and his girlfriend, Olivia,
Okay.
not them two.
So Trent's girlfriend is Olivia, is that right?
No.
Trevor.
Okay, well, it says in the police report that Trent and his
That's
girlfriend
confusing.
Olivia,
That's
so
what I'm saying.
I'm just going by that. I don't know them personally.
So your brother that lives with you at your mom's place is not the one who filed the complaint, right?
No, he did not file a complaint.
Okay.
It says,
It's confusing. All the names start with T.
All right, so we're going to want a protection order to keep him away from Olivia Kraft.
We have no objection to protection order, Judge.
Okay, Tanner, I'm gonna let you out of jail to go back and live with your mom, but you have to stay away from Olivia. Do you understand that?
absolutely, Your Honor.
And when you go to Shawnee, they are capable of doing mental health work there before you've had treatment there.
You
If
gave
they
me a
don't-
doctor's name, Judge, there.
If you don't want to go there, you can go to PATH in Chesapeake, which is a new facility at the Chesapeake Plaza, and you can walk in there and get mental health counseling.
I still intend on getting counseling. I just missed my last counseling appointment, so I tried to stay.
Well, you'll be there Wednesday for your other issue, so I would ask Wednesday if you can't get that rescheduled ASAP.
True, thank you.
Okay.
Okay, I'll set bond at $1,000 OR with a protection order, stay away from Olivia. When do you want to come back?
Judge, July dates I'm available, July 1st, 8th, 22nd, or 26th.
Well, under the circumstances, let's make it the first.
I can do
July
that.
1st.
I'm here, that's fine.
Okay, your next hearing is going to be July the 1st Mr. Quick, at the court in Chesapeake. You'll be out, so you gotta get yourself to the court. Can you do that?
Yes, absolutely.
You know where the court is?
Chesapeake Court?
Across from the flea market. You gotta be here at 10 a.m. on July 1st.
July 1st, 8 a.m.?
10 a.m.
10 a.m., July 1st, 10 a.m.
Week from today.
Okay,
Okay, that's all.
I appreciate it, thank you.
State of Ohio versus Kayla M. Sechrist, case number CRV 24373, CRA 243.
House on vacation till July 1st. Judge Hammers didn't want to touch it because it's out of warrant. I guess we'll come back next Monday. And Ray Nolan's not called me back or texted me.
Okay.
So, yeah, I got out the voicemail and I called Judge Ferguson's office and they're all gone till July 1st.
He'll be back in July 1st?
They'll be gone the 19th of June until July 1st is what it says, so I assume that means he'll be in the office.
So you want to set it that day?
If we could, I'm here that day. Unfortunately, and Judge, I understand, he just didn't want to, because it's Judge Ferguson's warrant lifted. I spoke with him.
Who did you talk to?
Judge Hammers, Sean Hammers.
Yeah. Brand new judge.
Brand new judge, yes, because I had his cell number, I just called, he answered. I explained the situation, but he still was hesitant to.
Okay, Kayla, sometimes you do stuff and it comes back and bites you. And this is one, you're not showing up and Cabell County's gonna bite you. Because the judge is on vacation until July 1st. I can't get your order lifted. Well then, we probably, maybe, possibly can get it lifted July 1st for you to get a treatment. But it's not gonna happen till then. So you're gonna have to sit in jail till July 1st. Or post a bond. I gave you a bond. Is there any possibility you can post any kind of bond? No?
Maybe, I don't know.
Do you want me to have Mr. Sowards call you, the bondsman at the jail? Discuss it with him? I'll do that.
Okay.
That's all I can do, Judge.
Okay.
I'll be here Monday for the,
I set it at 2,000. I might lower it if that would help, but
Appreciate it.
It got much difference in terms of what she has to post.
State of Ohio recalls Charles Evick at the Lawrence County Jail, case number TRC 24-1281A and B, CRA 24390. Hunter Tooley is on deck.
This is Mr. Morford's case, Charles Frick.
Yes,
This is Mr. Morford's case.
Judge, I talked to him, as you know, he's entered a plea to the OVI. He is somewhat confused as to why Georgia wants him. He thought everything was clear, but I've explained to him that they do have a request. He'd be returned to Georgia.
Well, how do you want to, I don't know if it's a mistake, they just didn't lift it, maybe they really want him. How does he want to handle it?
He is able to post probably 500 towards a bond.
Okay. So you want us, I can set a bond on both and let him try to contact Georgia and see if it's some misunderstanding?
I think that would be best because he thinks there's been a misunderstanding.
Okay, I will set it at $3,000, so that gives him some leeway on the bond. $3,000 cash or surety. So he wants to talk to the bail bondsman.
Yes, Judge. I'll contact Gary if you want.
And then when do you want to come back?
Week, maybe two.
July 1st?
Please.
Okay, I'm setting your next hearing, Mr. Frick, for July 1st. We'll have the bail bondsman contact you about posting bond. And then you gotta be back, you gotta be in the court here July 1st. You can contact the court in Georgia to see if there's some mistake. That would certainly help if they lifted the warrant that they have issued for you.
I'm gonna call the bail bondsman right now, sir, and he'll be in touch with you.
Okay, thank you.
Yes, sir.
State of Ohio recalls Hunter Tooley, Lawrence County Jail, case number CRB 24-385 A and D. Kimberly McCann is on deck.
It's Mr. Morford's case, pre-trial Hunter Tooley. We were getting an assessment done for some inpatient treatment for him.
We should be able to take him today. The jail was a little busy, so I just got through to him a few minutes ago, but his insurance checked out, so I think I'm just waiting on the full approval from the doctor, but we should be able to take him and pick him up today.
Okay, Mr. Tooley, I'm going to release you to hometown recovery for inpatient treatment. I expect a good report and that you do everything they ask you to do, when they ask you to do it, how they ask you to do it. I don't want any reports of disruptions from you. You understand me? I need good reports from you. I'm not very happy with the way you allegedly treated your grandmother. So any further problems are not going to be looked upon very favorably by the court. Okay, so I'll do an order releasing him to hometown, come back,
7.
July 8th. That's 2 weeks. Time waiver till then.
Yes, Judge, let me check the 8th for just a minute.
Okay.
I'm here then.
July the 8th will be the next hearing.
Thank you, Your Honor.
You're welcome.
State of Ohio recalls Kimberly McCann at the Lawrence County Jail, case number CRB 24-395 A and B.
You're welcome, ma'am. All right, Ms. McCann, someone here from the court contacted Mr. Sowers, and he says that he already talked to you.
Yes, sir. I just called his number, but my son and my daughter, neither one, they said, no, Justin Harris is completely out of my life, and they're not going to work. So basically, pretty much, they're not going to help me. My kids are. They're tired of Justin keeps getting in and stuff, and I just keep letting him swindle his way back in, and they're just not going to help me.
Okay, well, we need to move your hearing then up.
Yeah. Because my check doesn't hit until Friday, so probably Thursday, but Friday.
Do you have any money saved?
I did, but like I said, when he took my car, he took everything with him, so.
All right, Mr. Stratton, I'm going to go ahead and appoint you to represent Ms. McCann.
Yeah, I think I represented Mrs. McCann back in 21.
Okay.
Yep, so.
Let's move our hearing up to July 1st. 10 o'clock, maybe you can help. I put the bond at the minimum, 1,000 cash for surety. She says she has a job where she makes $55,000 a year, but she doesn't have any access to immediate money, and she's got a bunch of kids. It sounds like she's been helping all along, and now they're not going to help her.
Your Honor, I'd like to mention the fact that she had came to, in her last case, she came to every hearing. There wasn't any issues, and that was dismissed with payment of cost. So she didn't have any issues after being released on that. So I don't think she's a,
Well, she lives in Bowling Green, Kentucky now.
I know, she was living in Proctorville, but yeah.
I have a house in Huntington, West Virginia too. I mean, I'm not gonna go anywhere. If I can just get like something, what is that signature thing that I can sign? I promise I'll be here, like I'll be here. If you want to have it for this Friday, I'll be here. Whenever you can have it, I'll be here, but
Mr. Hill?
Your Honor, the facts surrounding this are so unusual looking that I'm going to have to look a lot more closely at what the allegations actually are. If Ms. Hargis, well, she says she doesn't have any reason to be around, Ms. McCann doesn't have any reason to be around Mr. Hargis at this point.
absolutely none.
That would be our chief concern, and we don't have an opposition to an OR bond.
Okay, I'll change it to an OR bond. Okay.
Thank you so much.
Still keep it on the first, Your Honor?
Mr. Hill is a big liberal, so he has that old softy. He's agreeing that you be released on a signature bond. Do we want to go back to the July 22nd? Because she wanted to go back to Bowling Green before she comes back for a hearing.
Whatever is good for you all, I'll be here. I don't care.
Well, she's got a job that she can keep, making $55,000 a year. Maybe she needs to get back there.
You want to put it on the 22nd, Your Honor?
Let's put it back on July 22nd.
Okay.
July 22nd for a pretrial, 10 o'clock. You're going to get out on a signature bond.
All right, thank you, Your Honor.
$7,000. Thank you.
$1,000 OR, yeah.
Your Honor, we just have a new one added.
Okay. New arraignment?
Yes. State of Ohio versus Matthew C. Medley at the Lawrence County Jail, case number CRB 23752 and CRB 23753 A and B.
Okay, that's not Matthew Medley, right?
No, Matthew Medley.
Who's on deck after Medley?
Nobody.
Okay, that should finish this up after Mr. Medley. And sir, you're Matthew Medley.
Yes, sir.
I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you do make statements, it's on the record. It can be used against you. You have a right to have an attorney appointed if you can't afford one. You have a right to bond and to make the state prove these charges beyond a reasonable doubt. You understand those things?
Yes, sir.
Looks like the most serious is a felony disruption of public services charge. It alleges, this is an old case, from November 30th of 2023, that Matthew Cornelius Medley at Perry Township purposely damaged, tampered with, interrupted, or impaired television, radio, telephone, telegraph, or other communication devices. That's a felony 4, maximum penalty is 18 months in jail, $5,000 fine. The B case is domestic violence. It alleges that Perry Township, November 30th, you not only caused or tried to cause physical harm to Carly Lawson, looks like, a family or household member. That's a first-degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine. Do you understand these charges?
Yes, Your Honor.
And you understand the rights you have?
Yes.
Do you have the money to hire a lawyer?
No.
Do you have a job?
No.
You have no income at all?
No, sir.
And Mr. Smith, I'll appoint you. And Mr. Medley, I've got a Canova address for you.
Yeah.
Sycamore Street.
Yeah.
State's position on bond.
The state is not.
Oh, there's also, let me, I didn't arraign him on one of the charges, I overlooked it. You've got an endangering children charge also.
Excuse me.
Sorry, it alleges on same time and place, you were the custodian or parent of children underage and you violated a duty of care, protection, or support, created a risk of harm to those children. So that's a first degree misdemeanor, maximum penalty, 6 months in jail, $1,000 fine. Okay, that charge is also in here.
Sir, I'm going to talk about your case. I'm going to call you at the jail. We'll talk in private. This is your lawyer speaking to you. I saw you raise your hand. I'll call you, ask me the questions, and if it's appropriate, I'll relay those to the prosecutor in court. I'm going to call you.
What's the state's position on bond for Mr. Medley?
State would request a $2,500 cash and surety bond, and also we're going to request a protection order.
Is that a bond you think you can make roughly 10% of that if you hire a bondsman?
Not right this second, no, I can't.
Okay, well, I'll talk to you about bond.
So you want to reserve on bond?
If we could, Judge, and I would call the jail.
I'll call it up. Well, I'm going to let you talk to your lawyer, Mr. Medley, and then we'll discuss bond and come back later and talk that. So we will come back to Mr. Medley at the jail on bond.
The jail is keeping him out. I'm going to call right now.
State of Ohio versus Kirsten Shipman, case number CRB 23698.
Okay. Kirsten Shipman is set for sentencing today.
Kirsten Shipman.
She was here.
Kirsten Shipman, come into court. Okay, it'll be passed.
State of Ohio versus Christopher J. Blevins, case number CRB 2286, TRC 21595 A and B, CRB 19439 A and B.
This is Mr. Stratton's case.
Your Honor, I have proof of additional community service. Leave that to me to hand that to you or to?
Yes, I'll give it to you.
This one's for you, Your Honor.
Okay.
Okay.
That's a good report from OVP. And it's got a report of doing community service and a good screen.
Yes, I think that's 5 hours on that, leaves them 25? 25 more to do.
Okay. Well, let's keep going.
Yeah.
Mr. Blevins, I've known you for quite a while. This is the best you've ever done. So
Thank you, sir.
congratulations. I'm proud of you. Keep it up. You can do this.
I've had you say that and I've ruined it before.
Well, but now we're going to forget about all that. You know,
Okay.
that's part of this. You know, the past is past, and the future is what we got to focus on. So you're capable of doing this. You just got to keep the vision in front of you. This is what you want to do, and then you're going to make it work.
Yes.
Okay? And you're going to do that, right?
Yes, sir.
Okay. Let's come back in August.
Yes.
What's your schedule in August?
I'm good in August.
Anytime?
Anytime.
Okay.
Your Honor, if I may, Mr. Blevins was not here for any community service.
Okay, well, that needs to get taken care of.
He was ordered on 5/24 to have some done before today.
I handed it.
He did hand in some.
Okay.
Yeah.
So it's in the file, 5 hours.
He does work a lot also, so that's why he's getting as much done as he can, so.
Okay, let's make it August 9th.
August 9th, okay. August 9th.
Thank you, Your Honor.
You're welcome.
Ohio versus Hope Nicole Hurd, case number CRA 24372. Your Honor, she has been picked up by Freeport County.
And Ms. Hurd was here on a rule court in Preble County. She's been picked up. Case here is dismissed.
State of Ohio versus Jonathan Malone, case number CRB 24319.
Mr. Stratton's case set for pretrial.
Your Honor, we spoke with the prosecutor about this, and if Mr. Malone would get an assessment for some treatment, the state said that and he goes through that and completes whatever their recommendations are, the state has indicated that they would dismiss this case. Okay?
Is that correct?
Yes, sir.
I think he's asking the prosecutor.
Mr. Hill?
That's what we want, Your Honor, and this comes from our alleged victim who wants him to get treatment. And we want to encourage that as well. And she does not want a protection order. And I understand he's a veteran,
Yes, sir.
so maybe the VA can be helpful.
Yes.
So we'd like him to go to the VA for services if that suits the court.
Are you familiar with the services available locally?
Not so much,
Okay.
but the VA, I know I have talked to them
You live where?
just outside of Cold Grove on 243.
Well, the most local place for you would be the one in Huntington, the Spring Valley. They have some really good facilities there, and they're very cooperative with the court. So I would prefer, I mean, you could go to Chillicothe, but they're not very cooperative with the court. So it'll be closer, and we'll get more information if you go to the one in Huntington. Do you have the contact info? There's a liaison.
I don't have that contact info.
I'll send it to you, Mr. Stratton.
And then I'll put it on your here.
You can pass that on to Mr. Malone. They're very helpful. Her name's Amanda Rayburn.
Yeah. Now that you remind me of the name, I have worked with her before, Your Honor.
You need to contact her?
Yeah, give it to me. Okay, so tomorrow, I should call Amanda Rayburn, or maybe we'll do it today, okay?
Okay, it's sent. Come back in a month, roughly?
Yes, Your Honor.
July 22nd?
Yes. No.
That's bad.
That's, yeah, the 19th and 22nd.
26th?
Yeah.
July 26th will be the next hearing for pretrial.
Hang on one second.
State of Ohio versus
Text message
Stephanie
didn't come out.
Pauley,
Bruce.
case
Just
number
have to see.
CRB
Then I'll give
24257.
that to you. Just
Stephanie Pauley.
Your Honor, she contacted me this morning. She's having some issues, some kid issues. She says she's going to be in this Friday. So I just asked that you wait 7 days before you issue a warrant.
All right. She has 7 days to appear. She has, the only problem here, why don't we continue this, because she has a bond out.
Oh, okay.
So once I release the hounds are hard to recall.
Yeah, yeah. So can we just put it on Friday's docket? That'd be fine.
I prefer to go a week. We've got a meeting scheduled for Friday afternoon, so I prefer
Oh,
to
okay.
that docket.
Oh, that's fine, Your Honor, and I'll let her
July
know.
1st. I think you're
The
all
first,
right.
yeah, the first.
July 1st for pre-trial. That's going to be
State of Ohio recalls Matthew C. Medley at the Lawrence County Jail. Case number CRA 23752, CRA 23753, A and B.
While we're waiting on them to get him in the chair, let's go ahead and go to the other cases.
State of Ohio versus Emily A. Smith, case number CRB 23627.
Mr. Stratton's case. She has been referred to Thrive, and I did get a report from Thrive that she's been in contact and doing what she needs to do.
Good.
She's at OVP, outpatient.
Outpatient OVP. How's everything at home? Good? She went home to her mother's, if you remember from Monday, Your Honor, so she... Yes. Okay. So if you want to also ask Mom how everything's going, you can also do that.
Okay. So I take it that so far with her outpatient, that's working.
Well, she just done her assessment the same day that she left OVP, so she should be going weekly, but that's the only appointment she's had at this time.
Okay. Come back in 2 weeks.
Okay.
Actually, the 12th would be better. You here the 12th?
Yeah, 12th is fine.
Let's make it July 12th. July 12th? July 12th, that's a Friday.
Thank you, Your Honor.
Yes, you're
Thank you, Your Honor.
State of Ohio versus Matthew Medley at the Lawrence County Jail.
Okay, he is on the screen, and it's Mr. Smith's case. They haven't set a bond yet.
It is, Judge. I spoke to him about bond. He believes he can make a bond in the neighborhood of $1,000 cash or surety. He says that the girlfriend that's the alleged victim lives in South Point. He lives at that Sycamore Street address in Canova. He's fine protection order. He's not going to come back across the bridge and have any contact with her, but I feel Gary would chase her just as hard for $1,000 bond as he would for a $2,000 or $2,500 bond.
We're okay.
I'll set bond at 1,000 cash or surety. Have you talked to Mr. Savage?
Not yet.
You
I want to
will
make sure.
contact him?
Yes, I contacted him on the other lady. He's contacting her. I'll contact him on this as well, explain what's going on.
And when do you want to come back?
Judge, I'm here in July the 1st or the 8th, or the 22nd or 26th. We'll waive time since he's getting out.
You said the 1st, 8th, and what?
The 1st, 8th, the 22nd or 26th of July are my available dates here.
Let's make it the 22nd with a time.
Yes, sir. Since he's getting out, I have no problem waiving time.
July 22nd is your next hearing, Mr. Medley, at the court in Chesapeake at 10 a.m.
I didn't ask you this when we talked. Do you have a telephone number I can call you when you get out to set up an appointment to meet me?
Yes, sir.
What's that?
304
Yes, sir.
412
412
7536.
7536. All right, you'll be getting out. I'll give you a call.
Thank you.
And you'll let Mr. Sowers.
Yes, I'm going to do it right now, Judge.
State of Ohio versus Cody J.W. Meade, case number TRC 23152, A, B, and C, TRC 221690, A and B, TRD 222101, A and B.
Mr. Smith's case for pretrial.
I'll move down. You just stand right there. You have to go far that way.
Yes. It's a good report. So sometime around July 1st,
I'm here July 1st or 8th, Judge.
finishing up.
Sounds like it.
We had an agreement where I just had surgery done on my ankle, that the 90 days is not going to be enough, that I'm going to stay an additional 30 days to the review of the next and give it time to heal up. I'm being managed on medications, and I think it'll be the best route to go to. I was wanting to do the sober living. I'm just not able to work in this predicament. But I plan on staying for a little bit longer than the additional time given.
Okay, you agree that's gonna happen?
Yes.
Okay, so we could push it out to maybe another month?
Yeah, we could do it the 26th, or that first week of August, I'm available. If that's even a little bit more time.
Okay, let's look at August. August 2nd.
Pull my calendar real quick. That should be fine, Judge. Yes, it's a Friday. I'm available, yes.
Okay, we'll put it down for August 2nd. You've done really well, Mr. Mead.
Thank you.
Keep it up. Good luck with your ankle.
Thank you.
Thank you, Your Honor.
State of Ohio versus Reginald Scherer, case number TRC 24763 A, B, C, and D. Reginald Scherer.
Mr. Smith's case, that's pretty
It is, Judge. The state has answered discovery. My client's been in the hospital the last 2 weeks. He was just released. I've not had a chance to get him into the office because of that. If we could come back a different date, we will waive time, and I can discuss with him what the discovery shows.
July 29th.
I'm in trial, I'm 26th I'm here, or August 2nd. He's asking for a Monday because of work.
Okay, let's do August. I can do August 5th.
I can do August 5th. Thank you.
August 5th.
I can get him in and go through the discovery.
So the original 90 days will run on July the 12th. There was a discovery demand and an answer, which we pulled it out a little bit longer, but we want a time window.
That's fine. Yeah, if you prepared, I was all prepared. It's possible. That's not an issue. Yes.
Thank you, Your Honor.
Okay, we'll just.
Yeah.
State of Ohio versus Paul Snavely, case number CRB 24318.
Mr. Smith's case, pre-trial.
I think we have a resolution, Judge. We've been going back and forth about sentence for a trial, but I don't think that's necessary. He is in counseling. The state indicates to me if he will successfully complete treatment, they'll look to just dismiss the case. It's an M4 disorderly, and he's got some defenses, but if they're willing to dismiss it, if he does what apparently he's doing, we're okay with that. And we'll waive time to accomplish that.
He's at Regal, is that where he is? Okay. All right, he's got good screen so far. Projected date, do you have a projected date of completion?
I think he's been here 4 weeks. I think probably 6 months, maybe 4 to 6 months.
Let's come back in 6 weeks or so, see what progress has been made, and so that's around the 1st of August.
I'm here the 2nd or 5th, Judge, either one.
August 5th will be the next one. August 5th.
9 a.m.?
10.
10.
Thank you, Judge.
You're welcome.
State of Ohio versus Nicholas Atkins, case number CRA 24294, CRB 24295, CRB 24293.
Mr. Atkins is at OVP. Complete on the 4th of July.
Yes.
I'm not here the 5th, Judge, but I am here the 8th.
And you're going to follow up with outpatient at OVP in Huntington, correct?
I have an appointment on the 5th.
He has done very well in treatment.
Good.
Yeah, I'm here the 1st if you want to see him right before he graduates, or the 8th, Friday after, either one.
Let's make it the 8th.
Okay.
July the 8th.
Thank you,
July
Ryan.
8th, 10 o'clock.
Hey, good work, man.
State of Ohio recalls Kirsten Shipman, case number CRB 23698.
This is sentencing.
24 CRP 293.
You can keep those as well.
Just one copy, but what do you have here?
That's your problem.
It's just one copy of the report.
Do you need a copy as well? I have one. I have another copy.
She made a statement. She wanted to dismiss. She here. It's the email they wrote.
She wasn't here.
He's a lawyer on that, Roger. Hey, Roger, on the last case. He just, that's it.
Go. She came this morning. Philip was out there.
We'll have to have her come in. I just want him to know that it's still pending. Okay. That's not what can you email me one of those,
Okay, how do you wish to proceed?
She's doing well. So it's really a matter whether the court is comfortable with maybe another month.
That's fine. Let's do that. longer she's in recovery, the better their odds and prove that she will remain in recovery, so.
And she looks great.
Yeah. Big transformation. Let's actually go into August. August 12th. Okay.
It's a Monday, Your Honor.
It is a Monday.
Thank you.
August 12th.
Will do.
Thank you, Your Honor.
State of Ohio recalls Jessica Coleman, case number CRB 24396.
Ms. Coleman, take a break to talk to the OVP representative, Ms. Dement.
Yes, and we did get her scheduled. She has an appointment scheduled for Friday at 11 a.m. So she is scheduled for mental health and just an assessment to see what she needs.
Is that going to happen in Huntington, or where will that happen?
Yes, at OVP in Huntington.
Okay. And I believe the state was okay with dismissing this. Is that
Yes,
correct?
Your Honor.
All right, I'm going to dismiss the charges. I would encourage you to continue with your treatment at OVP. They can help you.
Thank you, sir.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Danielle Hall, case number PRD 22175, PRD 24610, CRB 21371 A, B, and C, and CRB 21.
Yes. Salted RRS. Very good report.
Thank you.
How do you feel about it?
I feel great. I want to thank you for, helping me get my head on my butt and, getting back on the right track.
Okay. Very good. Okay, let's just keep monitoring things then. You've got some community service and fines to pay, so you need to start working on that too.
Okay, so I think all my fines were paid. I didn't think I owed any more fines.
No, I'm just looking at I'm going back to a case in 21.
Yeah, I paid $500 and some on the fines.
Okay, that may be paid.
Yeah. I know I still have the 5 days of community service to do as well, but right now where I work Monday through Friday and I'm doing my treatment on Saturday, kind of leaves me a little slim to none right now.
Okay, we'll wait a while on that.
Okay. And I do get sometimes one day that I work late, so if I do get that one late day, then I can come in on, that day that I work late and do a community service on that morning.
What's better for your work schedule, Mondays or Fridays?
Mondays are better for me.
August 5th will be the next hearing.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
Thank you.
State of Ohio versus Patrick S. Jones, case number PRC 19378, A, B, and C.
Your Honor, he's complying.
Okay, it's a good report from RRG. You have some community service and fines to pay too.
Yeah, I work Monday through Friday, and I just recently started getting my daughter again on the weekends. But I can get caught back up with it.
Okay, well, you'll have to figure out some way to get in here and do some community service. Can you make a payment on your fines today?
Yeah, $20.
Okay. So the clerk, You can also do Sundays if you want to get Ironton to work at the dog pound. You got to make an appointment to do that.
On Sundays?
Yes.
Okay. I'll check it out.
Need to talk with Mr. Cooper about doing that, but one way or the other, you're going to have to get it done.
Okay. I will.
August 5th will be your next hearing.
At 10?
10, yes.
State of Ohio versus Darren Alcorn II, case number CRV 23761, CRV 2496, A and B.
Mr. Morford's case, set for sentence. He was at Bethesda. Is he still there, or what's going on?
No, sir.
Taylor is not here, Your Honor.
I haven't been in Bethesda since the last time I was here. Hello. Since March.
Judge, he says he's not been to Bethesda since March.
Okay, I think we need a urine screen then today.
State of Ohio recalls Elizabeth Hoffman Howard, case number TRC 22164A and B, TRC 193458A and B.
Well, usually she shows up late, but today she hasn't showed up at all, so there'll be a warrant issued for failure to appear.
State of Ohio versus Jared R. Stover, case number TRC 24674, A, B, and C.
Have this down as a motion hearing?
Your Honor, this is the one that I,
All that you asked for.
yes, and
So you better not
Mr.
cover that if it's not, so.
Well, Mr. Eads has actually texted me 2 possible days.
You got some dates to suggest?
Yes. Monday, July 22nd, or Friday, the 26th.
Well, the 26th is actually better right now. July 26th for motion hearing at noon.
State of Ohio versus Brandon Call, case number TRC 24648, A and B.
It's Mr. Finley's case, set for motion hearing.
I don't know if there's anything else on the docket or not. Have you been back, have you seen my office? Yeah, I guess, Your Honor, if there's, this is going to be evidence, so I don't know if there's anything else that needs to be
Go
done.
through the other, I think there's other cases set for.
I've got a trial to present. Other than that, that's it.
Let's call wait and see if it's going to go for evidence.
State of Ohio versus Kyle White, case number PRD 24599, A and B.
This is set for a trial today too, and you're Kyle White.
Yes, Your Honor.
You don't have counsel?
So I did contact somebody, and I initially wasn't able to put down the retainer fee. I have been able, since help with family, to get that. He's actually in court. His name's Lee Booton. He's attorney from West Virginia. I talked to his assistant today. She said that he would probably want to try and file some preliminary motions or anything, and ask if I could get a continuance.
Well, I know Mr. Booton. I don't think he's licensed in Ohio that I know of.
I have no idea. That's who I was referred to from Bert Ketchum.
I know him too.
Yeah, I told him it was Ohio case.
They're not Ohio lawyers that I know of.
Yeah.
This is on the trial docket for today. And
We're ready to proceed.
the trooper's here.
Yes.
And no lawyers entered an appearance today.
Correct.
This is the same trooper on both cases?
It is.
Okay. Well, just have a seat, Mr. White. We'll get to your case later then.
Yes, sir.
We'll do Mr. Finley's case first.
Your Honor, may I be excused for a few minutes to go to the restroom?
Sure. So I'm going to take a brief recess and then we'll come back and start with Brandon Call. And I still have Darren Corn on a urine spray. So only 3 cases. Call, White, and Corn. Court's in recess.
Me too, I'm so sleepy. I gotta get up.
Kindergarten.
Oh, wow. You want us to go back to we didn't sit down.
It's what she's going to try on, Margaret. If you do go back there, make sure Arlo, you just keep talking and talking. Until we get started.
I'll slow him down.
Okay.
Oh, gosh.
Well, you know, they say if you want something, ask for busy person.
I believe that. I received that.
That's what when they come, Judge Kevin keeps on killing, or comes up with these ideas, I tell them, I say, get a healthy person that does, it's him all the time. It's hard to say no. It took me a long time. I just think I had to make excuses for people. When I realized I could just say no, I can't do that. I'm telling you, that was freedom.
I've been such a taker all my life, it's hard for me to say no now that I'm in a position to be. I knew like, and I just remembered this a couple weeks ago. I remember when I was 19 and I first started trying to get clean. I remember God telling me, like, when you get clean, because you're going to get clean one day, your life is going to be in service to other people.
Yes.
And I was 19 when, so like I had that choice then, and I was like, ain't no way. I'm not living for nobody else, I'm living for myself.
That's me, though. I was going to treatment. I had these, and I said, God, just get me sober, show me how to stay sober. I'll do whatever you ask me. He's kept his promise, so keep in mind.
That's it. You ever hear of a lady named Molly the other day? She was a big fan of Grand Law. She got drug cancer. And she prayed to God and asked God that he would heal her, that she took her whole life to serve him. And I think that's what she did. They really
Because I think that trial was set.
July 17th or something like that.
Yes. I wanted my wife's modified vacation plans, and I don't want to tell her, hey, we're going to this trial.
Well, you weren't going to do that trial, were you?
No, I always pick the jury in my cases, so I always do that, so. And I'm looking at that file this morning to talk to you about it, yeah. But I'm not going to step on his toes, but we are going to have a meeting with the guy, so just so
All right, so what do we got here?
You don't want to do it my way, have it your way.
to refuse, well, not only bad, but
That's for all
he
these
follows
years.
He's nice to him, he doesn't.
Well, I'll tell you what, I followed him for a while. The guy realizes he's being followed and he turns onto a dead-end gravel road.
Well, I asked him.
I enjoy, I've always been people, John,
I flexed me for so just before, so I wouldn't go on the highway.
I went way up in that road.
Well, I don't.
Strong odor of an alcoholic beverage,
this thing, you know.
coming from the bar, lost his balance coming out of the car.
I mean, it's not, he passes the law.
He does.
Yeah.
They don't. That's the way.
See you Friday.
I don't know.
See you, man.
I think he's guilty.
People.
Well, I know. Well, that's, I know.
I think I'm ready to go to the house. And I'm
I don't think there's any. I had to do all of them in this county. And I feel like, you know, I talk about being a rampart of reasonableness. I feel like it's a sandcastle, you know? And I have to be very, I just,
Oh, you see that? Yeah, I've seen the catfish.
if I start compromising then there's some reason to compromise. Unless there's something really strong about it that, I mean, I have to look at it and say, you know, well, I think yeah. Now you know what I mean?
I don't think there's a reason suspicion. Right down there as well, I've got six. Rose, we have an office there, because he says, I'm trying to stop you there, so get you out. I'll let you. Walk along. Have a good day.
Thank you, that is so cute. Thank you, it's good. That is Jasmine on vacation. She deserves it, for sure. Oh, she going? She went to Florida. Oh, wow. Yeah, Siesta Key or somewhere like that. Oh, good, yes.
I am also thankful, yes, I think you guys have extra credibility that you should. I don't care to do the damn hearing, that's the thing about it.
I don't care to do it.
I'm gonna ask her about, I'm gonna go to the bookstore and buy books. I'm gonna get some cards.
Orange County Municipal Court's now in session.
You're not a miracle.
Yeah, he's good.
Okay, so we're going to go ahead with the call case.
Yeah, the only thing is, Your Honor, this, I'm going to need this the computer to run the,
My client ran to the restroom there, but as soon as he gets back,
Okay.
to put the video on the thing, so I don't know if that takes John to do that.
Probably. Need Mr. Major.
He was helping us with his ear.
Sorry about that.
the state free to proceed?
Yes, Your Honor, the trooper had to go to the restroom real fast himself, and we also need John to help with this.
We have Mr. Major come in.
He's on his way, Your Honor.
This one there? Yeah. That should get where it needs to be, Your Honor.
Okay.
Is that all?
John.
Yeah, it's, actually gets where you need to be.
Thank you.
Ready? Well,
He went to the restroom.
okay. Raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Maybe see. Mr. Gibbons.
Thank you, Your Honor. Trooper, state your name and where you were employed.
Trooper White, State Hospital, Iowa, Post.
How long have you worked there?
Plus 7 years.
During that time, have you primarily been working as a road officer patrolling the highways? You make OVI arrests as a regular part of your employment?
Yes.
Were you on duty on March the 31st, 2024 at 2:23 in the morning? And at that time, did you come into contact with Brandon Call?
Yes.
At that time, was Brandon Call operating a vehicle?
Yes.
Did you come into face-to-face contact with Mr. Call?
Yes.
And if he's in the courtroom today, would you be able to point to him, please?
Yes.
I'll show you.
Where were you when you first saw Mr. Call's vehicle?
US 52, mile post 21 across the river.
Is that in Perry Township,
And that's in Fayette.
Fayette, here in Lawrence County, correct?
Yes.
And what drew your attention to him first?
As the vehicle passed me, it went across the perforated line. It was in the right lane. Went across the white perforated line and back in the right lane.
And as a result of that, did you begin to follow the vehicle?
Yes.
While you were following him, did you observe any other driving infractions?
Yes, a marked lanes violation, went across the white line and then back to the right lane. It was Neil Mark, 16.
And also, as you followed him, did he exit US 52?
Yes, it did.
And where did he go? Describe that.
Took a right onto Township, it's not Township Road 508.
That's what you put in the
Is it Township
report,
Road
is that-
508? Okay, yeah, the dead end gravel road, and
that's when I lit him up. I think right before that, I lit him up, and he continued up the gravel road.
Approximately where is that road?
It's at the intersection of County Road 60 and Country Road 508.
And were you heading west on US 52 at that time?
Yes.
And then what direction did he go, left or right?
He took a right.
And you say that's a dead-end road?
Dead-end gravel road, yes.
Did you follow him out that road?
Yes.
And at that point, did you initiate a traffic stop?
Yes.
And the traffic stop at that point, what was the basis for that?
The 2 marked lanes violations.
Now, before you actually made contact with him personally as you stopped his vehicle, did the lane violations, the time of day, the turning onto the dead-end road start to give you some basis to develop a suspicion that he might be impaired?
Yes.
Did turning onto the dead-end road appear possibly to be an attempt to evade you?
Yeah, I don't think he was trying to run away from me. I think he was just trying to get off the road.
Okay. Now, was your patrol vehicle equipped with cameras, the dash camera facing forward and a camera facing the back seat?
Yes, and body cam.
And you had your body cam, and were all 3 of those working at that time?
Yes.
Did you upload all those videos for use in this case?
Yes.
And did you review those before we had the hearing today?
Yes.
Stop here just for a second. Is that in the far distance there ahead of you, is those the taillights of Mr. Call's vehicle?
Yes.
Now, you were stationary when you first observed Mr. Call?
Yes.
And did you see traffic violations then, or marked lanes violations that would not be on the video?
Yes.
So before the video started, is that right?
Yes.
How does that work? Does the video, how does the video capture the, how far back does it go?
A minute 30.
Is that a minute and 30 from the point in time in which you light your,
Yes.
your, what do you call them, non-emergency lights, what do you call them?
Just overhead lights.
Overhead lights. So, So did he make the turn onto the Township Road 508 before you turned on your overhead lights?
It was as he was turning onto it, yes. I was trying to stop the parking lot.
And did he have other places that he could have stopped before he got that far? On
Yes.
that road? What you've seen in this video so far, were you able to see the driving infractions that you've described already that may not be clear on that video?
Yes, I was able to see him clearly.
Other than limitations of electronic equipment, is that a fair and accurate representation of
Yes.
what occurred? Now, at this point, did you decide to get out and approach the defendant's vehicle?
Yes.
And make personal contact? And did you find that Mr. Call was the one in the driver's seat operating the vehicle?
Yes.
When you first made contact with him, did you observe anything that might be possible cues that he might be impaired?
When I approached the vehicle, there was strong odor, alcohol odor coming from the vehicle.
Is there anybody in the vehicle with him?
Yes, there was 3 passengers.
Through your conversation, were you able to determine where they were coming from?
Yes.
Where was that?
They were coming from a bar in Huntington.
Was there a discussion about the reason for Mr. Call pulling off onto that road?
Yes.
And what did you find out?
He stated that they were just out driving around.
Was there anybody I guess nobody was going home on that road?
No, nobody lived on that road. No.
Is this a video of your body camera?
Yes.
How's it going on, man? I tried to stop you back there, what are you doing? I didn't know you were stopping me till they told me. They're like, well, what are they on? The lights are a pretty good indicator, you know? Yes, sir. Registration, license, insurance, all that good stuff. You got something from? Where is it? We're at Madison. What's your phone? Boots? Yes, sir. Someone live back here? Someone live back here? Yes, sir. We were just driving. You ain't got another day, brother. Yes, sir. You just driving on the Trails Road. Just get on 52. We were just driving. I just met this girl when you was in. I was trying to talk to her. Oh, dude. What's your phone number? 740-645-1887.
Now, does that video, what we've seen of it so far, accurately reflect what occurred that evening?
Yes.
So you had him step out of the car at that time? When he steps out of the vehicle, is there any further indication of possible impairment?
Yeah, he had to lean up against his vehicle. And then as we were walking back to my cruiser, he again lost balance.
1887? Yes, sir. What's the 288-06-1588? Excuse me, say Foxconn. Okay, yes, sir. It's all right here. You have any lines on it? Yes, sir. Yes, sir.
That video showed him leaning against the car and got out. Did it also show him losing? That's a question. Oh, did it?
Yes, yes.
And did it show, was that the best view to show him losing his balance as he was walking back?
No, the in-car camera would probably be better.
Was that, where does he lose his balance?
When he about fell into me.
I'd like for you to just indicate where it is that he loses his balance.
The first one was he would lean up against the car, and my eyes got out and shut the door. Next one's right there.
As you were speaking with him, did you have a discussion about whether he had anything to drink and how much?
Yes, he stated he had 2 beers.
1887? Yes, sir. What's the 288-06-1588? Excuse me, say Foxconn. Okay, yes, sir. It's all right here. You have any lines on it? Yes, sir. Yes, sir. How much that is? Yes, sir. How much that? Yes, sir. No, sir. Yes, sir. All right, stand back here for me, okay? Stand back here for me. Come on. Yes, sir. Say you have much to drink, right? No, sir. What'd you have? I had, 2 Bud Lights. Yeah, 12 ounce can, the 12 ounce can, and 16 ounce, they look, those are cup. Yes, sir. Booze? Yes, sir. And you're with them? Yes, sir. Where you at? I was having a job with them, sir. Where? Where there's no mid-turn, sir. Also, they say something, so, Western, sir. No, I was just following the directions, we were just driving, they told us turn, sir. I took a right up this road, this is my way, sir. Oh, okay, they say you turn here? No, I think this is, I thought they were telling me, yeah, they won't. I'm in that order, they were holding, yeah, we were just driving around, they said they were for lights, and we were just driving around, we just left. Yes, sir. Well, here's the deal, okay, I had small strong under that, that's all. That's why I said that. Okay, yes, sir. Now I'm in the car, now I'm talking to you, seeing this thing, okay. So I'm going to push it on that side, make sure I feel like you're okay to drive, you get out here. Yes, sir.
When you got Mr. Call out of the car and were talking with him further, did you continue to smell an odor of alcohol beverage?
Yes.
And did you feel like there was some question about his reasoning for making that turn on a dead-end gravel road?
Yes.
Given the sum of everything that you observed up to this point, starting with the driving that you testified to, the information you got about them being out of the bar, being after 2 o'clock in the morning, smell of alcohol, the questionable turn that was made onto the gravel road, the fact that Mr. Call admitted to drinking some alcohol, did that cause you to request that Mr. Call submit a standardized field sobriety test?
Yes.
Now, as part of your training to be Ohio State Highway Patrolman, did you complete the course in how to conduct standardized field sobriety tests?
Yes.
And you're competent to conduct those, is that right?
Yes.
How many, well, you do this on a regular basis? Is that right?
Yes.
And the tests that you conducted are those that are approved by NHTSA, approved by the state of Ohio, that are developed by NHTSA, is that
Yes.
right?
Yes.
Prior to the hearing today, I asked you to review your materials for the NHTSA manuals.
Yes.
2018 manual is
Yes.
one that you have used and were trained on, is that right?
Yes.
And you've also familiarized yourself with the 2023 manual?
Yes.
No. It's too many pages. They're just copies from those. Which one are these from? 18 and 23. Oh, these are, this is 18. Yeah, just in case you try to throw that trick at me. I want to show you what I have marked as State's Exhibit 1 for identification and ask you if you recognize this set of pages.
Yes, that's the NHTSA manual.
And what's the year?
2018.
And ask you on State's Exhibit 2. Tell me what that is.
23 version of the NHTSA manual.
These are the instructions that you were trained on, is that right?
Yes.
And did you conduct standardized field sobriety test in this case?
Yes.
You want to ask one of the two people?
Any objection?
Well, Judge, I didn't go through those thoroughly, but I think that statutorily under subsection D, I mean, the standard is the current manual that's in force at the time of the arrest, so that would be the 23 manual. So I don't see any reason to.
Not all of your colleagues agree with that.
Well, it's pretty clear in the statute, I think.
Okay, subject
So
to-
I have no objection to either one of them, to be honest with you, Judge.
Okay. Be admitted.
But just for the purposes, just so the record's clear, Judge, I think if you look at 4511.19D, I think, or maybe it's subsection E, it talks about the test should be given in compliance, substantial compliance with the current standards, which would be 23 here in this case.
All right. That's noted.
That way we would save some time there. I'll see.
All of them do double.
I got you.
Just want to make
Okay.
sure. Are the standardized field sobriety tests designed to provide indicators of alcohol or other substance impairment?
Yes.
So prior to actually performing these tests, you ask some questions to make sure that the person is physically able to accurately perform the test and you can get an accurate reading.
Yes.
And what are the things that you ask?
I asked him if he's had any head injuries recently, if he's had any back or lower leg injuries that prohibit him from walking.
Did you do that in this case?
Yes.
And did you determine if there were any physical cognitive limitations that would keep you from being able to get an accurate read from the tests?
No, there's no physical limitations that he had.
You heard about that? Yes, sir. We had any head injuries recently? Yes, sir. We had any back injuries, leg injuries, anything like that? Yes, sir. So I want you to know.
Okay, so at that time, did you begin and to conduct the horizontal gaze nystagmus test?
Yes.
So let's talk about what is horizontal gaze nystagmus. What is it?
Well, what I'm looking for is I'm looking for the involuntary jerking of the eyes, which is nystagmus.
And why is that?
It's an indicator of alcohol impairment.
I'd like for you to explain step by step how you conduct the horizontal gaze nystagmus test.
Yes, I'm gonna tell him to put the feet together, arms down at the side. I'm gonna tell him, I'm gonna hold my finger up. I'm gonna tell him to focus on the tip of my finger. When I move it side to side, follow it with their eyes open, keep my head still. And then I'll go into equal tracking is the first thing I'm looking for, and equal pupil size. Next thing I'll go into is lack of smooth pursuit. I'll do 2 passes with each eye with that. Then I will go into distinct and sustained nystagmus, set max deviation. I'll go out 2 sides each eye. I'll hold my finger out there for a minimum of 4 seconds, maximum of 30 seconds. And then the final thing I'm looking for, well, not the final, but the next thing I'm looking for is the onset of nystagmus at 45 degrees. Again, I'll check each eye twice, going out to 45 degrees. If I do see nystagmus prior to 45 degrees, I stop, verify it, and then I'll go to the other eye. And then typically the last thing I'll do is check for vertical gaze nystagmus.
Arms down the side, keep together, heels to the toes. Okay, stay in that position, right? See, what I'm gonna do is I'm gonna hold my finger up beside this. I'm gonna move side to side. Keep that face straight, hold my finger right, right.
vertical gaze nystagmus?
Yes.
And explain what vertical gaze nystagmus is.
So vertical gaze nystagmus is when I go up, if the eyes have nystagmus, it just means that that person has consumed whether BAC is high for that specific person. It's not general, like, for everybody, it's for that specific person.
So in this case, as far as the horizontal gaze nystagmus goes, what clues did you observe?
606 clues.
And when you did the vertical gaze nystagmus, did you recognize any further clues?
No.
I'm going to show you what's marked as State's Exhibit 3 identification and tell me what that document is.
This is our HP 70, which is our impaired driver report.
Is that the document that you filled out in this case?
Yes.
And does it show indications of what you observed on the horizontal gaze nystagmus test?
Yes.
And what does it say?
Distinct nystagmus in both eyes, lack of smooth pursuit was in both eyes, and onset nystagmus before 45 degrees was in both eyes.
According to NHTSA studies, what is the likelihood that a person has a breath alcohol concentration of 0.08 or more if you observe 6 of 6 clues in the horizontal gaze nystagmus test?
I believe it's 88%.
Did you conduct the walk and turn test next?
Yes.
And I would like you to explain what the walk and turn test is, how it's performed, and how you explain it, what instructions you give to the subject.
So I'm going to have them line up, typically I have them facing their vehicle, and I'll tell them to imagine a straight line coming from the left foot to the rear of their car. I'll have them put their left foot on that line, put their right foot in front of the left foot, touching heel to toe, with their arms down to their side, and remain in that position until I tell them to begin the exercise. When I tell them that way, actually I'm getting ahead of myself, then I'll go into explaining the exercise, excuse me, and then demonstrating it. So I'll tell them they're going to take a series of 9 heel-to-toe steps down the imaginary line. When they get to the 9th step, take a series of small steps, turn themselves around, and take 9 more heel-to-toe steps back down that same line. And then I'll just explain to touch heel-to-toe with every step, put their arms down to the side, look down their feet the entire time, and count each step that they take. And then I'll tell them once they begin the exercise, and I'll stop till it's complete.
So did Mr. Hall perform the walk and turn test?
Yes.
Did you have a discussion with Mr. Hall about the service that you had there at Gravel Road, and that you, about maybe that you might see if you wanted to move to a different kind of service before performing the test?
We did.
And what was the content of that discussion? What was the term?
Well, I asked him if he would like to go down to the parking lot where it was a flat surface and no gravel, and he stated he would not like to do that.
So, since we are on this road right here, okay, I'm going to ask if I can take you down to the class upstairs. Is he okay with that? You know, okay with that? Okay, we'll try to do it right here. That's good, sir. Okay, well, just forewarning, we are on an uphill slope with gravel everywhere. You're okay with that? Fair enough. Come stand right here for me. Okay, straight on up. Okay. Once you imagine a straight line comes from your left foot, straight on out. Okay? Put your left foot on that line, put your right foot in front of your left foot, touch heel toe. Come the other for me now. I'll explain to you. Just go ahead and put your right foot in front of your left foot. Heels up, arms down your side. Don't move from that position, okay? When I tell you to begin, you're going to take a series of 9 heel toe steps. Down this line here, this imaginary line. When you get to your 9th step, take a series of small steps, turn yourself around, and take 9 more heel toe steps. Back down that same line. Okay. I'll demonstrate it for you. So you're in this position right here. Yes, sir. You're going to get back in that position for me. Yes, sir. Arms down your side. When I tell you to begin, first step. 1, 2, 3. I took 3 steps. You want to take how many? 9. On that 9th step, you got front foot on the line, hit your straight leg separated. Series of small steps, just like this. And then take 9 more. Give it 2 steps back down that same line. 1, 2, 3. While you're doing this, your feet touching your heel toes at the step. Keep your arms down on your side. Look down at your feet the entire time and count out your step that you take. Does that make sense? Yes, sir. Once you begin the exercise, don't stop the exercise complete. If that makes sense, you can begin whenever you're ready.
I'm going to show you Exhibit 3 again, ask you to tell what clues of impairment that you observed in walking term.
He moved his feet in the instruction phase.
Now, observing that video again, did he make the turn in the proper manner?
When I went back and rewatched it, after I wrote the written report and sent it off, he took 10 steps instead of 9, which caused him to turn the wrong direction.
Anything else that you observed?
He lifted his arms off the side 6+ inches. It was close. That's why I didn't count it.
So did you conduct the walk and turn test next?
The one leg stand test.
I'm sorry, one leg stand.
Yes.
And explain what that test is and how it's performed and what instructions you give.
So what I'm going to do is I'm going to put them in the instruction phase, which is heels to heels, toes to toes, arms down either side. I'm going to tell them to remain in that position until I tell them to start. Then I'll go in and explain the instructions. I'll tell them they can pick either foot, whichever one they're choosing, pick it up 6 inches off the ground in front of them. With that foot 6 inches off the ground, and have their arms down to their side. They'll look down at that raised foot and count out in the manner that I tell them. And then when I'm done, I'll remind them, foot 6 inches off the ground, arms down to their side, make sure they're focusing on that raised foot.
You did all those things in this situation?
Yes.
Instructions.
Now stay right here for me. Turn face me. Push feet together like this. Arms down your side. Stay in that position until I tell you to start, okay? When I tell you to start, you're going to pick up either foot. Don't care which foot you pick up, it's whichever one you choose, okay? You're going to pick it up 6 inches off the ground in front of you, just like this. Okay? With that foot 6 inches off the ground, you're going to look down at that raised foot, so this one right here, and you're going to count out like this, 1,001, 1,002, 1,003, 1,004, so on and so forth until I say stop. Make sense? Yes, sir. While you're doing this, keep that foot about 6 inches off the ground. Keep both legs straight. Keep your arms down on your side. Make sure you're focused on that raised foot. Okay? And begin now. Now, 4, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14. Okay, you can stop. You can stop. Stay down here for me.
What clues did you report on the one leg incident?
Sways while balancing during counting, raises arms 6 inches from the side for balance, and then hops.
According to NHTSA studies, what is the likelihood that a person would have a breath concentration of alcohol of 0.08 or greater if they showed 2 or more clues?
I believe it's 77%. Can't recall at this moment.
Is it a high likelihood?
Yeah, yes.
This document here, Exhibit 3, do you recognize this as an authentic copy of the report you made in this case?
Yes.
I'm going to ask that the admitted.
What number is it?
This is number
3. Any objection?
No, Your Honor.
Be admitted.
All of the video that we have shown here, do you recognize it all as an accurate depiction of what happened?
Yes.
I want to ask, did you watch the exhibit before and ask that it be admitted?
Yes.
Which
Video.
video? Oh, no objection, to that, Your Honor.
Video is admitted. Number 4.
Now,
This would be the body cam, correct? Or you admitting both? Just-
body cam and dash cam.
No objection.
As a result of everything that you observed from the starting with the driving, turning on the dead-end road, strong odor of alcohol, 5 in the morning, 2:30, something in the morning, information you received that they were coming from the bar in Huntington, loss of balance after leaving the car and as you walked back toward the cruiser, continued strong odor of alcohol, admission to drinking, performance on the field sobriety test. Did you then determine that it was appropriate to place Mr. Call under arrest for OVI and a lane violation?
Yes.
Now, did you do that?
Yes.
Did you offer him a breath alcohol test?
Yes.
And did he agree to submit to a test?
No, he refused.
That's all I have.
Prosecutor.
Thank you. Good afternoon, Trooper Blake. We've met before, I believe, right?
Yes.
Okay, been a while, hasn't it?
Yes, it has.
So you, when did you graduate from the academy?
2018.
Where did you go first?
Orange County.
You've been here the whole time? Okay, gotcha. All right. So if I ask you something you don't understand, let me know, I'll clarify it. Ask a better question, is that fair?
Yes.
Okay. So when you handle an OVI stop and the subsequent arrest, several documents you got to fill out?
Yes.
Okay. It starts with the ticket, doesn't it, or the
Yes.
citation? You reviewed that before today?
The ticket?
Yeah.
I have not looked at the ticket, no.
Okay. Wouldn't be anything on there that you want to change, I assume, right?
Not that I'm aware of, no.
Okay. And then you also do your statement of facts or narrative,
Yes.
and you did review that before today, right?
Yes.
Okay. Any changes you want to make to that?
I would just, the one leg stand, the one that walk and turn, those clues that I,
That would be on the impaired driving report, though, wouldn't it?
yeah, that's what, is that what you're talking about, the statement?
I'm talking about your narrative report, your statement of facts. This
Yeah. it's-
statement of facts, you call it statement of facts. That's what I'm talking about. This document.
Yeah, I'm sorry, it's all the same thing, but
Okay.
yes.
The HP 70 goes with that, right?
Yes.
Okay. All right. And then you also do a BMV 2255 form.
Yes.
That has to do when Mr. Hill just asked you about him refusing to take the test?
Yes.
Okay. And let me just mark, this is exhibit 1. I just show you. Is this a true and accurate copy of the BMV 2255 you completed after the arrest of Mr. Call?
Yes,
And you see what I've got highlighted down there in the bottom right-hand corner?
yes.
Okay. No one swore to this then, correct?
No, that is incorrect.
Is incorrect?
Yes, the witness signature. Trooper
Well, I'm
Bean.
asking, okay,
That's the witness signature.
state trooper?
That's just what we have to do after when we send this off to the BMV.
Okay, I understand that, but what I'm looking for is the arresting officer's signature, that's your signature, Bob, correct?
Yes.
Okay. And I'm talking about in the last section down there, that says State of Ohio, Lawrence County, Ohio. No one, it's blank, anybody swearing your signature, you agree? See that's highlighted portion there?
No, I see exactly what you're saying, but that's not true. Trooper Bean witnessed me reading
Okay,
it.
but who signed that? Is
Oh,
there-
yeah, I don't
My
know.
question, is there a form somewhere else where someone swore to this?
The BMV would have that, yes.
Okay. Yar, could you check that on the court file, is that compare this with what's been filed in the court? So you're telling all the one, the witness signature is Trooper Bean?
Yes.
Okay. But below, no one has executed this document. This is over, correct?
Well, no, they did. That's just what we have to do before we send it off. We don't have to do that right when we're on scene.
So you believe the one that you sent off to the BMV is going to be signed by Trooper Bean or someone here where that highlighted portion is?
Yes.
Okay. Well, this is what I got discovered.
What's in the files the same, is what exhibit,
Okay.
things exhibit one.
Are you aware, Trooper White, that document's supposed to be in its final form that's sent to the BMV, also sent to the court in that exact form?
No, I did not know that had to be signed.
Would file completed sworn copy with the court. That's under 4511.192E. You're not familiar with that?
No.
Okay. In fact, you're required to send a copy of that sworn report to the court no later than 48 hours after Mr. Call's arrest. Are you not trained that?
Can you rephrase the question, please, Mark?
Within 48 hours after the suspect's arrest, you're supposed to send a completed copy, the same one you send to the BMV, to the court.
I was not aware. I just always send it with my report whenever I get that done.
Okay. Judge, just so that the court's reviewed that, let the record reflect that Exhibit 1, Defendant's Exhibit 1 is the same thing that's been sent to the court. So your cruiser's equipped with dash cam body, and you have body cam, one was in working order, we've seen that, correct?
Yes.
Did you review that before your testimony today?
Yes.
Okay. Did you meet with Mr. Hill and he provided you with a set of questions he was going to ask you?
Yes.
Okay. So you went over everything, what your testimony would be here today?
Yes.
Okay, all right. So let's talk about the stop of Mr. Call's vehicle to start with. You're sitting in the median around, what do you say, around milepost 21?
Yes.
Okay. Facing the westbound lanes?
Yes.
Okay. Mr. Call is coming by you in the right lane, correct?
Yes.
Okay. And you claim that he went across the, what you call the perforated line, I think. I like that. Perforated line, was that before he passed you, or as he was passing you, or after he passed you?
After he passed me.
Okay. I noticed in here it doesn't say how many tire widths or anything like that.
No. I don't know how many tire widths.
At that point, had you made up your mind to stop him?
No.
Okay. You didn't pull out and get behind him, right?
Yes.
Okay. And this is at milepost 21 where you're located?
Yes.
Okay. And there's a 90-second delay when you activate your dash cam before it actually starts recording, correct?
Yes.
Okay. Is the fault line violation that you talked about on direct, is it captured on your video? I think you said it was.
It's on the video, yes.
Okay, we won't play it how much you point out for me. Because when you pull him over, it's around milepost 16, right?
No. When the violation happens, it was in that area, milepost 16.
Okay. So about what milepost is this road he turns on?
It's about the 15.25, maybe.
So is it, and these are, obviously they're called mileposts because there's a mile between each one, right? Okay. So is it your testimony you followed him for about 6 miles?
Yes.
Okay. If I can show the video here. Okay, so right here, Trooper White, as you can see, so that's Mr. Call's car that he's operating ahead of you?
Yes.
Okay. And your testimony is that he would have went across the white fog line by at least a tire width?
Yes.
Okay. Will you please tell me to stop the video when you observe that violation?
Can't see. The picture's not good enough. I can't see. Give an exact location of that happened. All I saw was taillights in the video.
Would you agree with me what we're showing right here is that there's no, he's not crossing the white fog line?
I would disagree.
Well, tell me where it is.
Well, I can't tell. I can't tell you
So you
exactly
say that
where
that's too far away, you need to be closer?
the dash cam, yes, would need to be closer. All you can see is taillights.
Okay, well, would you agree with me that you can see the white line the whole way down through there? From the beginning to the end, I mean, the white line.
I mean, you could see the white line, yes.
Yeah. Did you ever see a tire even touch it?
I believe, yes, I did.
Okay, well, did you want me to rewind? Did you tell me where it is?
Well, I couldn't tell you on the camera. So
You can't tell me on camera. Did you and Mr. Hill talk about that and determine where it was?
No, I don't believe so.
And in order for it to be a valid stop, you're trained under the new case law in Ohio, it has to be tire width that has to cross the
Yes.
line, right?
Yes.
And your testimony is somewhere on this video, at least in your mind, that happened.
Yes.
Okay. We'll live with that. You got a belt microphone as well, right?
No.
You have a body cam there. When do you activate that?
It activates when I open my car door.
Okay. But when we see you sitting in your vehicle at the median, when you pull out, and you go to your body cam, it's on, right?
No.
No? Okay, let's look at it. So right there, that you're in your car, your body cam's on, is that right?
Yes.
Okay. So it's on while you're driving?
Yes.
Okay.
So each one, when it activates the picture or when it activates the voice, the audio recording?
I'm talking about the camera.
Okay, yeah, the camera goes back 90 seconds, I believe.
Okay, all right. But the voice isn't activated till you open the car?
Yes.
Can you manually activate it?
The
Voice?
I can turn it on, yeah, but I mean, it's already on, but activate the voice
Yeah, where it's recording what you're saying.
in the car?
Yes.
No.
No. And the
I
dash.
don't believe so. There may be a way. I'm not aware of it.
You don't have a belt mic anymore like you used to, you don't have dash cams?
No.
When you pull Mr. Call, you line him up there just as he's in the process of making that right turn, correct?
Yes.
And he makes the turn properly?
Yes.
Signals?
Yes.
Okay. And then there's like a concrete area there, you said a parking lot, is that what that is?
Yes.
Okay. And you make the statement to him when you approach, well, actually, it's when you get him out of the vehicle, you say, I tried to stop you back there so we could do these.
Yes.
And you met Phil sobriety test, right?
Yes.
Okay. So at the time you were letting him up, you didn't know who he was, right?
Correct.
Didn't have any
Suspicion of any alcohol at that point as far as any personal contact, right?
Personal contact, no.
Okay. So you'd already made up your mind you're going to perform a field sobriety test based on what you've seen to justify the stop. So it sounds like.
I always try to stop somebody in a location where if I need to do fields, then we have a good spot to do it.
Okay. So my question is, though, had you made up your mind that whoever the driver of the car was going to be subjected to field sobriety test at that moment?
Before I made contact with him?
Yeah.
No.
Okay. But you told me about it, right? We hear it on there. I wish you would stop back. I wanted you to stop back there so we could do things on the pavement.
I did say that, yes.
Okay. The NHTSA manual excerpts that Mr. Hill gave you, you were trained, you would have been trained in the 2018, in your class, the 2018 manual is your manual, right?
Yes.
And have you been trained on the 2023 manual formally?
Not formally, no.
So you haven't had any classes on it or anything?
No.
All right. But you are aware that's the current manual?
Yes.
All right. So I've got your manual here. If anytime you want a reference to it, let me know, okay? All right. So we go through these vehicle motion factors, right? Fair, you know what I'm talking about, right?
Yes.
There's several of them, correct?
Yes.
So like weaving, you didn't see we don't see him weaving, you agree?
Agree.
You don't see him weaving across the lane of traffic, clear to the other lane and all doing it?
No.
Okay. Or drifting. Driving pretty straight when we're seeing this.
Other than when he made the mark lights violation, yes.
Okay. Which we can't identify.
On camera, yes.
Okay. Straddling a lane line? Well,
If you want to count the mark lanes as straddling or lane line, yes.
by the way, even though you say we can't see it on the camera, how far over the fall line is he?
I don't know exactly, I can't give you an exact measurement.
Two tire widths, three tire widths?
No, he wasn't on the wrong strips, no.
Okay. What, did his tire in fact go over the white line?
Did it go over the white? Yes.
Okay. One time?
Yes, I believe so.
In about 6 miles?
Well, yeah, at the first violation that I witnessed.
That's the perforated line?
Yes.
Okay. All right. He wasn't swerving?
No.
He didn't almost strike anything, another vehicle or an object?
No.
Even when he turned?
No.
Didn't turn with a wide radius?
No.
Nope. He stopped, pulled off the road, even though I know it's a township road, only looked like.
Yeah.
No issues with that, right?
No.
Okay. Wasn't accelerating, decelerating? It would give you an indicator of somebody's impaired?
He tell he hit his brakes a few times, but no, he wasn't speeding. I don't recall.
But I mean, he wasn't going fast and slowing way down and then going fast again? No clue there, correct?
No.
Okay. Not varying his speed at all?
Not enough for me to notice.
Okay,
Yeah.
that's fair. And he wasn't going, one of your factors here is at 10 mile per hour or more under the speed limit?
Yes.
You didn't note that, right?
No.
Okay. Had his headlights on?
Yes.
Used his signal when it was proper?
Yes.
Responded appropriately to you, pulling over? Right?
Yes.
Okay. Obviously, following too close, there's no other vehicles around, so that's not applicable here, agreed? No improper lane changes?
No.
And didn't drive off the roadway, you said he didn't hit the rumble strips or anything like
Right.
that, you certainly would have noted that.
Right.
Okay. And he didn't exhibit any unusual behavior, like slumping over the wheel or things out the window or anything like that?
No.
Okay. You didn't find any alcohol containers or anything in the vehicle?
No.
So, when you approach him at the window, you ask him for license, registration, insurance, you said all that good stuff, I think's how you put it.
Yeah.
He provided that to you properly?
Yes.
Didn't fumble with it?
No.
Drop it? Understood you? You understood him?
Yes, for the most part, I believe.
So, in your report, do you have your statement of facts there? Or?
I do not.
Let me just, you got to put it in. If I could just direct your attention here down to the middle of your report here, to the right. You state here, asked for his driver's license, he provided it, and identified himself as Brandon Cole. We talked about that. You state here, due to the strong odor of an alcoholic beverage coming from the vehicle, I had Mr. Call step out.
Yes.
Right? There's three passengers?
Yes.
So you were asking to step out to perform field sobriety test?
I was going to have him, yes, at that time I was.
And when he gets out of the car, that's when you see sort of somewhat lean against the car. He didn't grab it to hold on or anything like that. He sort of leaned against it.
Yeah.
And as you mentioned, where the vehicle's parked is on a slope?
Yes.
Okay. Gravel road?
Yes.
Okay. How much of a slope is it? It's hard to tell from...
I don't know the percentage. I mean, it was a slope. It was a little uphill.
Okay. Not flat, right?
No.
Okay. Do you know how long he'd been driving in the car before you stopped him? At least from Huntington, right?
Right.
Okay. At that point, according to your report, when you asked him to get out, you hadn't made any other observations at that point, right? You wanted to get him out?
Correct. I wanted to separate it from the car.
Okay. So when you get him back, and you're standing there, just you and him, you again smell odor of alcoholic beverage?
Yes.
Okay. And did you know what kind of beverage it was?
No.
Okay. Can you detect the difference between beer, whiskey, and...
No, I can't.
You can't, okay. You have talked about, I think in your paired drivers report, exhibit 3, that's up there, you take a look at that. Where you have take a look at that, so they're the same thing. You have on here speech slur.
Yes.
Have you ever met Mr. Gall before?
No, I have not.
You guys spoke for several minutes there along the road.
Yes.
Give me an example of a couple of words that you believe he slurred.
It was when I first made contact with him. When he said he was coming from Huntington, it sounds like he was starting Huntington.
It sounds to me, and feel free to disagree with me, it sounds to me like he was talking okay. You got him out of the car, would you agree?
Well, I mean, I said he slurred, so I believe he slurred.
You didn't have nothing to compare that to, did you?
No.
Okay. You didn't have any trouble understanding him, right?
A little bit at first. When I got him out of the vehicle, no, I wasn't having a hard time understanding him.
I mean, he rattled off his phone number, social security number, and all that to you,
Yes.
correct? Okay. There was no drugs or drug paraphernalia in there, anything like that?
No.
He told you he had 2 Bud Lights, I believe,
Yes.
in a cup.
Yes.
Did you ask him when he last drank anything?
No, I did not.
Did you ask him how long ago, or excuse me, over what period of time, when he started, when he ended?
No, I believe it is.
That'd be important though, wouldn't it? Could be.
It could be, yes.
There wasn't any cover-up odors or anything that you, I know you got, there's 3 women in there, could have been perfume. But you didn't detect
No,
that?
I did not detect any of those odors.
Okay, all right. And when you got him out of the car, brought him back, when you explained the instructions of what you were going to do, he understood those, right?
I believe so, yes.
And he was compliant with you?
Yes.
Okay. Didn't give you any trouble with, you
No.
basically did what you asked him to do?
Yes.
You, first test you administered is a horizontal gaze nystagmus test?
Yes.
Okay. Do you, is it your testimony, you believe you did that substantial compliance with the NHTSA
Yes.
standard? The NHTSA standard that you were trained on in 2018?
Yes.
Okay. And I'm not going to, I mean, we're going to put the video into evidence, so I'm sure the judge will review that. I just want to go through some things here, and I'm going to take up a whole afternoon with it. So you tell him to put his feet together, his hands down his side. Did you tell him to keep his head still?
Yes.
You think that's on the video?
Yes.
And that's important, right?
Yes.
Because if he's moving his head, the eyes on the track, right?
Right.
Did you tell him to keep looking at the stimulus until the test was over? Because I don't hear that on here.
I told him to focus on my finger.
Did you tell him to keep looking at it until the test was over? I don't believe you did.
I don't remember. I don't recall.
Do you know that's part of the instruction you're supposed to give?
Yes.
So equal tracking, did you check for equal pupil size to start?
Yes.
Okay, did you note that anywhere?
Did I check for it?
Yeah.
No, I would only note it if it's,
Abnormal.
it would be, yes.
Okay. So equal tracking, how many passes do you make when you check for equal tracking? You?
2.
You make 2 here?
Each side.
Okay.
One with two each eye, yes.
All right. And what are you looking for there?
I'm just making sure that both eyes are following the stimulus.
All right. And the first clue you're looking for is lack of smooth pursuit?
Yes.
Okay. And according to your manual, there should be a clear distinguishable break between checking for equal tracking and checking for lack of smooth pursuit, because you're going from determining if there's a medical impairment and actually into the cues of the test. Is that fair?
Yes.
Did you do that?
No, I did not.
You didn't, did you?
I did not.
That could compromise the results of the test, is what they trained, right?
Not sure if you can compromise the entire test, but it is something I am supposed to do.
Okay, I appreciate your candor. So you didn't do that here. So when you started with lack of smooth pursuit, you start with the left eye, suspect's left eye?
Yes.
Okay, you did that here, right?
Yes.
Okay. And you go out 2 seconds,
Yes.
and then back all the way across the subject's field of vision to the left 2 seconds. The
Yes,
right eye.
2 seconds out, 4 seconds across to the other eye, and then
Okay.
4 seconds back. Do that 2 times.
It's 4 seconds. Could you show me where that is in what Mr. Hill?
From, once I go out, it's 2 seconds.
Okay,
Back all the way across, it's 4 seconds.
okay.
And then back all the way across, 4 seconds.
Okay.
Do that twice.
And do you think that's in your manual, it's 4 seconds to go back across?
To go all the way back across, yes.
Yes, okay, all right.
2 plus 2.
Bill's a big word sucker. You noted clue in each eye. So each eye there was a lack of smooth pursuit.
Yes.
Did you indicate that on your body cam?
Did I voice it?
Yes.
No.
Are you trained to do that?
I have never been trained to voice
They don't
everything
train
I
that?
see on the camera, no.
You were a trooper when they had the dash cams, you had the belt mics, you were supposed to articulate that, right? Back then.
I had a belt mic for like a year and a half. I never did that.
Okay.
Was never trained to do that.
So then you're checking for distinct nystagmus and maximum deviation, right?
Yes.
That's the second clue you're looking for?
Yes.
Okay. Tell me what you did on that.
I start off with his left eye again. I go out, hold my stimulus, hold my finger out there for minimum 4 seconds, maximum 30 seconds.
And why is 30 seconds the maximum?
I believe you get fatigue. Your eyes get fatigued. I believe this is what it is. Yeah.
Exactly. How many seconds did you hold on this?
I believe it was 6 seconds approximately.
Okay. And what did you observe?
Nystagmus.
Okay, tell me is that visible on your body cam?
Probably not.
No. You would agree with me, I was white on the body cam, right? You would be able to see a bouncing of the eye?
No, sometimes it's faint.
Okay.
I mean, the camera's not going to be able to pick that up.
The bouncing of the eye?
Yes.
Okay.
Unless it is very, very, very strong.
And that's not the case here?
I mean, it wasn't super strong, no.
Okay.
But it was there, yes.
Okay. And then you also got that in his right eye?
Yes.
Okay. Did you make 2 passes?
Yes.
And then the onset of nystagmus prior to 45 degrees, how did you estimate the 45 degrees?
I don't know how to estimate it, but it's out to right there. It's not fully out, but it's a 45-degree angle.
Do you have anything that you do to practice to make sure
that it's exactly 45
Or
degrees?
it's close to it?
Not that I'm aware of, no, there's no.
You ever heard of a template?
Exact, a what?
A template?
I have not.
It's in your manual. They talk about practicing with a template. You don't recall that?
No.
Okay. So, at that point, once you obtained the clues that you got on ESGN, had you made up your mind to arrest Mr. Call at that time?
No.
No. Okay. So then you moved on to the walk and turn test, right?
Yes.
Okay. And as your exhibit 3 here that Mr. Hill put into evidence, you got one clue.
Yes.
That's how you determined at the time you were
Yes.
doing it, right? Which would mean one clue would indicate that he's not going to test over .08. Is that fair? It takes more than 2 clues.
No, that's not true.
Well, 2 or more clues indicate a likelihood that a person's going to test over .08. That's what your man says.
Well, it's the totality of all the circumstances, so the other
Well, the-
tests are included in that decision.
A battery test,
Yes.
right? So, but when he asked you about these percentages, if you get 2 or more clues, what's the percentage that a person will be likely to test over .08?
79, 82, something like that.
Okay, well, let's use that, okay?
Okay.
So 79 or 82, let's just use 82. So if you don't get those 2 clues, isn't it just the logic the opposite of that, that then it's likely that person is not going to test over .08 if they didn't get 2 or more clues?
No, not in my experience.
No?
No.
You don't like that logic?
Not in my experience. That doesn't always play out that way.
Okay. So what, a person that gets 0 clues on the walk and turn, what's that mean to you?
Means they have very good balance.
Does it mean they're not impaired?
No, it does not mean they're not impaired. I've had alcoholics.
If a person,
can turn perfect, and
if you get 0 clues on the HGN, 0 clues on the walk and turn, 0 clues on the one-way stand, you still believe the person could be impaired? Even though you got 0 clues on all 3 of the tests?
if I have 0 clues on all 3 of those tests, I am not arresting somebody for OVI.
Okay, because that's what these are. These are probable cause tools, are they not?
Yes.
Okay. And then we move on to the one-way stand.
Yes.
Okay. And you admit to me that this is on slope, right?
Yes.
And it's gravel.
Yes.
It's not a non-slippery surface, would you agree? Gravels roll when you're standing.
Yes.
Okay. And you're trained to, these tests, when they were formulated, scientifically were done in a controlled environment in a lab, basically, weren't they?
I believe so.
Well, they're in a controlled environment. They weren't done on the road.
Well, they tested them on the road, but I don't.
And weren't you also trained that if these are not given in certain conditions, high, dry level, non-slippery surface, that the results will be compromised?
Could they be? Sure, they could be, yes.
You train that, right? You try to find the best location you can.
I tried, yes.
So when you gave him the one-leg stand, tell me what your instructions that you gave him. If I'm here and you're going to administer this to me, tell me what you would tell him.
I would tell you to put your feet together, heels, toes, arms down to your side, and then remain in that position until I tell you to start the test. Then I would go into explaining the test. He's going to pick up either foot of his choosing, approximately 6 inches from the ground. With that focus is at 6 inches from the ground, he's going to look down at the raised foot, count up the man that I instruct him to. Then I'm going to tell him to keep his arms down to the side, look down at his raised foot the entire time, keep both legs straight, and then count up the man that I told him.
So if we go through this and break this down step by step, and I'm taking this from your training manual, stand your feet together and your arms down your sides, right?
Yes.
Did you demonstrate that?
I don't recall.
You're supposed to, right?
Yes.
Show them what you're doing.
Yes.
By the way, did you tell Mr. Call how he's going to be scored on this?
No.
Like what clues you're looking for?
Don't believe I'm required to.
Well, I'm not saying you are, but I mean, you ever take a test and didn't know how you're going to be scored?
I don't know.
It'd be unusual, would it not?
Law school.
I have no idea.
So the second part of this is do not start form the test until you do so. You told me that, right?
Yes.
And then do you understand the instructions so far? You never asked him that, though, did you?
I asked him at the end if he understood.
At
He
the
said
end.
he did.
But not after you gave the first two instructions.
I don't recall.
Okay. So how would you know that he understood what you were doing at that point?
He stated he did.
Well, not at that time because you didn't ask him.
Okay.
You wouldn't at that point. You wouldn't know, right? Obviously, you didn't ask.
Okay.
You agree?
Yes.
Okay. And this, when I tell you to start raising the leg with the foot approximately 6 inches off the ground and keep your foot parallel to the ground. I don't hear you use the word parallel anywhere.
I don't recall.
The video would show it, right? That's the best
Yes.
evidence, right?
Yes.
Keep both legs straight, your arms down at your side. You told me that, right?
Yes.
And then, while holding that position, count out loud in the following manner: 1001, 1002, and so forth, up to 30. You recall telling him to count by thousands?
I believe it was 1001, 1002 is that's how I normally do it. So,
Okay.
yeah.
And then keep your arms at your side and keep watching your foot. You tell him that, right?
Yes.
And then you're supposed to ask him again, do you understand? I think you did at that time.
Yes.
And at the conclusion of this test, did you formulate, was that when you decided you were going to place him under arrest?
Yes.
Okay. And it gave you no issues, right?
No.
Other than having to go use the bathroom over the weeds, right?
Very long time. Took me a very long time too, if I can recall.
So when you offered him a breath test, we're not talking about a portable breath test, right?
Correct.
Did you offer him that test and reading the BMU 2255 at the scene or at the post?
At the scene.
Okay. You don't have an acceptable breath test in your car, right? I know that when these Intoxilizer 8000s first come out, they had a handle with it, so they were going to walk, take them around, fit in.
Yeah, I don't have those anymore.
You don't have those anymore, right?
No.
So he couldn't have taken that test there at the scene if he wanted to, could he?
No.
Okay. When you wrote your statement of facts, Trooper White, did you remember when you did that? I know you probably don't. When do you normally do that?
It's within a couple of days, depending on how busy I am.
Do you go back and watch your body cam when you write it?
Typically, yes.
Okay, did you do that here?
I don't recall. Believe I did. I tried to.
Okay.
Yes.
That's your standard procedure normally?
Yes.
Right? Okay. And the same thing when you're filling out your impaired driver report?
Yes.
You do those documents at the same time?
Yes.
But you wanted to change that impaired driver's report today to add some clues, is that fair?
Yes.
Even
Well, I'm not going to change it, no. I'm not saying I can change it. He asked me a question, I just pointed something out.
You good with sticking with what your document is?
Yes, that's what's on the paper, that's what I stick with, yes.
All right. I have no other questions. Thank you, sir.
For your record.
Don't have anything, Your Honor.
You may sit down.
And we rest, Your Honor.
Any evidence to move on?
Judge, the only thing I would do is ask to move into evidence. I think I've marked it as defense exhibit 1. I don't know if I gave you.
I have
Yeah. That's,
it. Any objection?
No, Your Honor.
Be admitted. All right, do you want to make any argument?
Well, Your Honor, I think that officer performed his duties sufficiently, that there was probable cause for the arrest. I think that the driving, this gets discussed frequently about the technical limitations of the dash cam recorded through electronic equipment onto a TV screen up on the wall, as to whether, if the officer says he saw a Mark Lane's violation, why isn't it on the video? Well, I don't know, because it's 200 yards ahead, and the officer can see it better than the camera can record it. So we believe that his testimony on that was very credible. And the rest of it, we believe, is also, I think that the field sobriety tests speak for themselves, particularly the one-leg stand. I mean, it was pretty obvious that he lost his balance pretty severely on that. And I think that overall, the officer's testimony was very credible, and that the motion should be denied.
Judge, I'd be happy to submit a written brief on these issues, because there's numerous issues I have here. First of all, with the stop, and I appreciate what Mr. Hill is saying about that with the camera, but, you know, when the white fog line is in, you can see it the entire time. I mean, if the tire would have went over, the car went over, it would be, to say that that is, you know, not captured on this video, when the white fog line is in view the entire time. I mean, it's bright white, you can see it on there. That's disingenuous. I mean, I don't know how you can say that that's not, that there's a violation there, and I understand. But, I mean, I get that argument if you got a dash cam, if you're on a curvy road or something, and, you know, it's close, you know, it's not even close here. So that's issue one. Issue two I have here is, there's a lot of case law out there, and it's been updated since last year, a year or two ago. But I mean, there has to be an articulable suspicion of OBI to remove Mr. Call from the vehicle to perform field sobriety test. The testimony here to the report is it was a smell of alcohol. That's why I asked him to get out to perform field sobriety tests. And case law is very clear on that. There has to be more than that. There has to be more than that, even coupled with the driving. So that's the second issue. Third issue is with respect to the horizontal gaze nystagmus. I don't believe that's substantial compliance. I mean, there's too many things there that wasn't told. As the officer said, it does compromise the validity of those tests. The one-leg stand, I mean, you know, it's on a slope, gravel, the instructions weren't properly given. I mean, these guys are supposed to, they're depriving people of their liberty. I mean, they should be able to do these correctly, at least in substantial compliance. And I'm not picking on Trooper White, you know, but it is what it is. So those tests, I think, and then, you know, obviously the walk and turn test, I mean, for lack of a better word, he passes. I know they'll tell you it's not pass or fail, which is correct, but they usually say that. But I mean, that's an indicator that he would have tested under. I know it's a battery test, but if the battery test is flawed by the procedures not being administered in substantial compliance, then, you know, that calls into question the whole thing. And then with respect to, we put the administrative license here in with this as well. I think that should be granted today, Judge. It's very clear that they didn't comply with the statute. I mean, that's our exhibit one there. I think it's very clear the statute wasn't complied with. That's why I asked you to check the court file. So I'd ask that be done today. I don't know what argument could be against that.
Mr. Hill, any response?
Well, you know, the issue of the administrative license suspension and the form being properly executed, we don't take a position on that. If there should not have been an administrative license suspension, then that's something that I had not considered up to this point. Was that in your motion?
Well, it's in the ALS. It's a separate motion.
Yeah. So I don't know. I don't take a position on the ALS issue. I mean, I think the trooper's correct that just because a person does manage to perform one of the tests without a whole lot of indicators doesn't mean that they're not impaired. And really, I mean, if the the surface upon which these tests were performed is an issue, then he did really well on the walk and turn test, and that would be the one that the gravelly road would have the most impact on. The other one, the one-leg stand, he was standing still. And that's the one where it was obvious that he did not perform very well on. There were a lot of indicators there that he was impaired. His balance, he lost balance pretty severely. So we just feel like there was probable cause for the arrest, and he was in substantial compliance on the field sobriety test.
Judge, can I just say one more point I forgot to mention? The other thing, Judge, I think it's a bigger issue than that, even with these the field sobriety tests. Trooper White's testimony was he has not been trained under the 2023 manual. I believe that that's statutory. I think that's in subsection E, 4511.19, section E, now I think about it. But that requires, at the time of the arrest, that they have to be trained in the current manual. And I've had that in other cases in our district here, so.
Well, to me, that would be, if there was a difference,
Well, there are
There's
differences.
going to be some differences, but what are they? I mean, if he's doing things under the 2018 and he hasn't updated, then I can see a problem. If it didn't change.
Well, Judge, I mean, that's not for us to, we don't have that burden of production on that. That's on the state. But the statute says they shall be trained in the current, at the time of the arrest, the current one. And I appreciate Mr. Hill bringing the 2018 manual, because that's what he was trained in, but he testified he doesn't. Now, I had one Megs not too long ago where the officer said, I don't have that manual. I don't even have it. I wasn't trained in it. I was trained in, I guess, even before 18. And that's happening because they're not sending them to their in-service like they're training to get the new manual. I guess it's probably my fault. I should have asked him to even have this 2023 manual.
Okay, I'm going to grant your motion on the ALS. You prepare an entry.
I should will.
And then, do you want to submit it, or do you still want to give me a written?
Could I have just a couple of weeks to submit something on those issues there? I know they're a little bit unique somewhat.
Yeah. When do you want to submit it, then I'll give the state as time to respond.
I'm in 2 weeks, Judge. I've had you something in 2 weeks.
Okay, so that's the 8th, I believe. That'll be July the 8th, and then state can submit something by the 15th. Or do you need 2 weeks? 2 weeks would be the 22nd.
Yes, Your Honor, 22nd would be good.
Okay, so defendants will be July the 8th. State, July 22nd. So I'm going to put it on my calendar for review, for decision. So no hearing or anything, but that just remind me to look at it and take a look at those and issue a decision at that point. Anything else?
No, thank you, Judge. Not from us.
Okay. So the next hearing date on the calendar will be the 27th. Yeah, July 22nd. Now, is Mr. Korn submitted to the hearing screen?
Yes, sir.
Okay. Do we have results?
Yes, sir.
I need Mr. Korn's results, please.
State of Ohio versus Dan L. Corn on a recall.
Thank you, sir.
Case number CRB 2496A and B.
I don't have it written down, Your Honor, yet. He just went, but it's THC, alcohol, and Suboxone. Waste positive.
Well, how's the state want to proceed in this?
So back in March, Mr. Korn pled guilty to some things. And we delayed sentencing. And what we represented at that time was that if there were no problems, then we wouldn't request any jail time. But if there were, then we would request jail time. Now, I don't know if this rises to the level that the court would consider that problems, but it's certainly not a good thing. I don't recall what the discussion was about treatment, but I guess he was at Bethesda first. Yeah, that was back in
He was at Bethesda.
March 18th.
Yes, so to speak.
And he was a new also.
Your Honor, I've continued my treatment at ANEW, but when you released me from Bethesda, I haven't returned there, obviously, but I've continued with ANEW.
Okay, I don't have a report from them. So what I would suggest at this point, to continue there, get in touch. We've got a victim or alleged complaining party in 23761 Charlie Mitchell. Let's have some contact there. I know there was Victoria Bolden came in and asked for the protection order not to be enforced, to be withdrawn at some point, but maybe some follow-up with those folks. Yeah, she was the one that was on the menacing.
She's a teenager.
And of course we've got her resisting too, so. My concern is that I want to see a change with Mr. Korn and that some assurance that these kind of behaviors aren't going to happen in the future. And it seems to me that he was doing really well at first, and now that's been relaxed quite a bit. And I think he's decided that he's got things under control, and I'm not sure he does.
If I may.
Yeah.
I don't come in front of you with any excuses, Your Honor. I always do as you ask of me. Even when you put me in treatment, I didn't go in there with the dirty urine screens. I'm just not a drug user. That's not the issue here. It's an argument with my girlfriend, and I don't know how to assure you that's not going to happen again because.
Well, not only with her.
You have to understand, Your Honor.
But just with her, I mean, we got two women, and we got a police officer.
Yes, sir. Yes, sir. I understand, Your Honor, but I'm not here with a lax attitude at all. That's not my position.
Okay, well, you got a chance to go back. I want something from ANEW, and that your screen is not what it should have been. I believe. Let's see it. So I'm going to go out on a limb and say the folks that are prescribing the buprenorphine probably don't think you should be drinking alcohol with it, right?
I've never been told that, but it's possible.
Is the new prescribing
Yes.
buprenorphine?
I'm not even on it anymore. I took the Sublocade shot like 2 months ago. I haven't continued it since then. I was told that could possibly show up in a urine, but I haven't even continued it because I don't need it, Your Honor.
Well, get me a report. How often are you going to the new?
Every 2 weeks.
Okay. I want you to go back. When's your next scheduled appointment?
I just seen her on the 18th, so.
Okay, so that means
around the 10th.
July 2nd or so,
Yeah.
you're going back. Furnish him with a copy of this. I want you to take it to your counselor and tell him that the court wanted you to report as to what happened when you came in for a review. And I want some response from them as to their direction to you. or you to be consuming alcohol while you're, and if you're not taking buprenorphine, then they need to give me a report as to that effect. But, anyway, you've not convinced me that this is never going to happen again. That's what I want to be convinced of, okay?
Yes, sir.
So,
I'm trying my best.
well, you can do better. You can do better. Look, we can all, it's a human condition. I talk about athletics a lot because that's what my mind works. But you know what? When you get out and you get pushed, you can always do more than you think you can. You get in a circumstance where you're pushed to do something harder than you've done before, a lot of times you can do it. You're coasting along and not doing a whole lot. It's not like you're getting pushed to do your best. You are not. And that's what I want to see. You got to commit. I mean, you still got jail time over your head. I want to be convinced that I'm not going to turn you loose on the community and you're not going to resist an officer or assault some woman that you have a relationship with and be right back there in front of me, and I'm going to feel responsible because I didn't push you to get to the point where that's not going to happen again. You understand me?
I do.
So come back and let's pick a date when you're going to be back here and have something from anew. So about July 15th, Mr. Morford.
Judge, give me just a second. I'm not sure if I got
15th or 22nd?
July 15th. I'm good then, Your Honor.
July 15th, and I want a report from anew. Acknowledging that they've seen your screen today. Okay, we'll see you then.
Thank you.
Bring a good report from the new. That says you've got all your issues under control. Okay.
State of Ohio versus Kyle White.
Thank you,
Case number
Judge.
TRD 24599 A and B.
All right, so this is set for trial today. I'm going to leave it up to the state. If you want to try the case today, we'll try it because he's had multiple chances to get a lawyer and hasn't. If the state's okay with continuing it, but the things that you represent to me, Mr. White, don't make any sense. I know Lee Booton, I know him pretty well. He's never practiced in this court. I've been here 30 years. He's never had one case in this court. He's not licensed in Ohio. So that doesn't make any sense that you're telling me you've got an appointment to see him. If you told him it's a case in Ohio, he's going to tell you. I'm pretty sure. I'm confident he's going to say, Mr. White, I can't help you because I'm not licensed in Ohio. I can't try a case in Ohio. How's the state want to proceed?
Well, what I would like to do first, Your Honor, is just maybe let Mr. White know what we would recommend if he were to plead guilty, if he wants to do that.
Fair enough. Go ahead and do that.
This is a first offense, Your Honor, and there was no test. It was, I guess it was a refusal. Our recommendation would be a 6-month driver's license suspension that would go back to the date of the stop, which would be March the 23rd of this year. So he's about halfway done with the suspension. And we would not be opposed to driving privileges for work or whatever other things that the court would think is appropriate. And we would ask him to attend the 3-day driving school. And if he did that, we would not ask for jail time. We'd ask for suspended jail time. And we would take no position on the amount of the fine or any other sanctions.
Well, there is a minimum of 375, so that has to be at least that.
Understood. I do
All right,
have,
Mr. White, in effect, you're representing yourself today, so what say you?
I do have one question, from Trooper White's, perspective. He did take me back to the station. I did sign a paper that said that if I did not sign it and take the intoxilizer 3,000, that I would have a 90-day suspension automatically. He signed that, or I signed that. I blew into the intoxilizer 3 different times. He said, I'm not gonna mark you down as a refusal. He crumbled up the paper and threw it in the trash. I did not refuse. I don't know why the officer, if he truly believed that I was under the influence, wouldn't have, taken me to do a urine tox screen or a blood test at that moment.
Let me see if I can answer that, Your Honor, because it may be that there's
That's
some...
truly what I'm trying to figure out.
The report says there was some kind of RFI interference.
Yes, that's right. So there wasn't a refusal.
Yeah, I tried to cooperate 100%. I promise you that.
Okay, so it's up to you. Do you want to still ask for continuance, and I'm going to let the state decide if they want to go forward or continue it today?
I'd like to ask that, but at his mercy.
Okay, what does it say?
Well, we've got our trooper here, so I guess we ought to proceed.
Okay, we're going to have a problem. Okay, forfeiture.
Judge, can I get you signed?
You ready to go on this one?
Sure.
Okay.
So the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Please.
Trooper, state your name and where you are.
Trooper White, State Highway Patrol, Iron Post.
How long have you been employed with the Highway Patrol?
Around 7 years.
During that time, is your normal job to be working out on the highway patrol?
Yes.
Did you happen to be on patrol on March the 23rd, 2024, at 2:02 in the morning? And at that time, did you come in contact with Kyle White?
Yes.
At that time, was Mr. White operating a vehicle?
Yes.
Where were when you first saw his vehicle, and what did you observe that caused you to notice it?
I was sitting on at a crossover, US 52, off Post 21, when Mr. White, who's at the defense table over there, passed me. We traveled over the white line and was riding on the rumble strips for approximately 100 feet or so.
And what did you do as a result of that?
I pulled out and began to follow him.
Did you initiate a traffic stop?
Yes.
When you were following him, did you notice any other driving infractions or erratic?
Yes, he made, I believe it was 2 more mark lanes violations or 1 more mark lanes violations, but yes, he committed another mark lanes violation.
Was your patrol vehicle equipped with a dash camera and a backseat camera and a body, were you wearing a body camera as well?
Yes.
And were all those functioning and recording at that time?
Yes.
And did you upload all the video for use in this case?
Yes.
And have you had a chance to review it before today's hearing?
Yes.
Before I play the video, you described Mr. White's vehicle traveling on the rumble strip.
Yes.
Was that as he passed you or after he passed you?
It was just after he passed me.
Did that make it onto the video?
I don't believe so, no.
Is that Mr. White's vehicle in front of you?
Yes. I believe that's where the Mark Lanes was.
Is that an accurate depiction of what occurred that evening?
Yes.
At this point, do you then approach the vehicle?
Yes, I'll make a driver's side approach.
And when you got to the driver's side, there is Mr. White operating the vehicle?
Yes.
And I believe you may have done this already, but do you recognize Mr. White in the courtroom today?
Yes, he's at the defense table.
That's the court to recognize that
He has identified the defendant.
Now, when you make initial contact with Mr. White, did you notice anything that might indicate impairment?
Odor of an alcohol beverage coming from the vehicle.
Did Mr. White tell you where he was coming from?
Yeah, he was coming from Huntington, and he was heading home to, I believe it was Russell, Kentucky.
Did he mention where he had been in Huntington?
I believe it was at a bar. I have to look at my statement to be 100% confident about that, but I believe it was a bar.
Do you recall whether he told you that he had any alcohol to drink?
Yes, he stated he had 2 beers. I believe he said there were 16-ounce beers.
Two? Yes, sir. Just the cans, 16-ounce cans, 12-ounce cans, 16-ounce cans?
Just lost out of the house so far.
Okay. Is that what did you meter that water?
Yes, sir.
Okay. And look at it for a second. Okay. Thank you. But the reason I got to stop because you went out a couple times. Just check on you, make sure you ain't drunk like that.
Yes, sir. I'm so sorry.
Is the car registered to you?
Yes, sir.
Is it? Okay, don't worry about that. Just stop off on real quick.
Yes, sir.
At that point, did you have to get out of the vehicle?
Yes.
And when he gets out of the vehicle, do you observe any other clues that he might be impaired?
I continue to smell the odor of alcoholic beverage from this person as we're walking back to my cruiser.
Now, given everything that you've observed up to that point, the driving, the time of the morning that it was, the admission that he'd come from the bar, he consumed alcohol, the smell of alcohol, did you have a reasonable suspicion that he might be impaired? And did that lead you to request that he perform standardized field sobriety tests?
Yes.
Now, as a part of your training with the Ohio State Highway Patrol, have you completed a course in the appropriate way to administer standardized field sobriety tests?
Yes.
According to the accepted NHTSA training, is that right?
Yes.
And what year did you complete that training?
2018.
And you're also up to date on the current training from the 2023 manual?
We haven't had any formal training on that. However, I have looked at the manual, just in my personal time.
Is there anything radically different about the 2018 procedure and the 2023 procedure that would make you not be able to properly conduct those tests?
Not that I can tell.
I'll show you what I'm marking as. That's Exhibit 1. Ask you, show Mr. White first.
Yeah. Thank you for showing me.
I'll show you what I marked as State's Exhibit 1. Ask you what that is.
It's the 2023 version of the manual.
And you familiarize yourself and would agree that those are authentic pages from that manual?
Yes.
You're competent to conduct those tests?
Yes.
Right. I'm going to ask that Exhibit 1 be admitted here.
Any objection, sir?
No, Your Honor.
Be admitted.
So what's the purpose of standardized field sobriety tests?
To determine if someone is impaired on either alcohol or drugs, and also can tell the level of impairment that they are at that time.
Did you conduct the horizontal gaze nystagmus test first?
Yes.
And I would like for you to explain what horizontal gaze nystagmus is and how you perform the test, how you explain the test.
So horizontal gaze nystagmus is what you look for is an involuntary jerking of the eyes, which is known as nystagmus. So how I have to perform this test is I have to put the feet together, arms down to their sides, and then remain in that position. I also put my finger up with a stimulus, tell them to focus on the tip of my finger with their eyes or eyes only, keeping their head still. That's when I'll go into looking at equal pupil size, and then I'll do equal tracking. After the equal tracking, I will go into lack of smooth pursuit. I will check each eye twice, After doing lack of pursuit, I will go into distinct, sustained nystagmus at maximum deviation. Again, two sides each eye, two passes each eye. I hold it out there, minimum 4 seconds, maximum of 30 seconds. After doing that, I will go into the third, which is the onset of nystagmus prior to 45 degrees. For that, I'll again check both eye twice. I'll go out approximately 45 degrees. If I see nystagmus prior to 45 degrees, I will stop, verify it, and then go on to the next eye. And then with vertical gaze nystagmus, I'm doing the same thing except I'm going up instead of horizontal.
So I want to first complete talking about horizontal gaze nystagmus. And so Mr. White submitted to that test, is that right?
Yes.
No, not for you?
No, sir.
Yeah, you stay fine out there for me. Just stand right here for me. Stand right here. My last one.
Yes, sir.
You gotta face me. And just stay right there. Alright, man, so, the reason I had to step out is because I smelled the other alcohol coming from the vehicle, okay? You said you had 2 beers?
Yes, sir.
Okay. If you're being honest, if you had 2 beers,
Yes, sir.
you know, I think it'll be okay. But I'm gonna check it real quick just to make sure you're the right drive.
Yes, sir.
Alright, I feel like you're good to drive, we'll get you out of here, I'll take you somewhere, yeah, okay?
Yes, sir.
You wear contacts?
No, sir.
Okay. Can you take your hat, flip it backwards for me?
Yes, sir.
Have you had any head injuries recently?
I have not, sir.
No. So what I'm gonna do is I'm gonna hold my finger up just like this, okay? You can head face straight forward and follow my finger with your eyes and eyes only, okay?
Yes, sir.
Can you see my finger?
Yes, sir.
Just keep your head nice still for me, right? Okay, keep it right there.
Yes, sir.
See it?
Yes, sir.
The light's not blinding, it's not there to see it, so. How's that? Sorry. So, yeah, I knew you'll see it. That's what I appreciate you telling me. Okay, so I'm gonna go up, so you can ask no.
Yes, sir.
All right, so at that point, did you then move on to the vertical gaze nystagmus?
Yes.
And what is the vertical gaze nystagmus, and how do you conduct that test?
So I'm gonna have him keep his chin level for me, and then I'm gonna go up. It's the same, basically the same thing as distinct and sustained nystagmus and maximum deviation, except this time I'm going up. I'm looking for nystagmus, which is the involuntary jerking of the eyes. What that means is it's that person specifically has consumed a high amount of alcohol for him specifically. If I see nystagmus over.
nystagmus. What clues did you observe?
Lack of smooth pursuit was 2 of 2 clues on that. Distinct and sustained nystagmus and max deviation was 2 of 2 clues. And then onset of nystagmus about 45 degrees was also 2 of 2 clues.
So was that a total of six
Six.
clues?
Yes.
On the vertical gaze nystagmus, did you note any clues on that?
No.
I'm going to show you what I marked as State's Exhibit 2 and ask you to identify that document.
Yeah, it's HP 70. It's our impaired driver report.
And what did you report about horizontal gaze nystagmus on there?
Distinct nystagmus was 2 of 2. Lack of smooth pursuit was 2 of 2. And then onset nystagmus prior to 45 degrees was 2 of 2.
Thank you. Ron, can I see Exhibit 1? I'm going to refer you back to Exhibit 1, which is the NHTSA manual pages. And let's see here. According to NHTSA studies, if a person exhibits at least 4 out of 6 clues, what is the indication, what is the percentage likelihood that a person has a breath alcohol score more than 0.08?
88%.
Did you move on then to the walk and turn test?
Yes.
Can you explain what the walk and turn test is?
Yeah, so I'm going to have him face his car, with his back to my car. I'm going to tell him to imagine a straight line coming from his left foot to the rear of his car. Have him put his left foot on that line with his right foot in front of his left foot touching heel to toe. And then with his arms down to the side, and remain in that position until I tell him to begin the exercise. Once I tell him, correction, I hit myself again. Then I'm going to go into explaining the exercise. I'll tell him to take a series of 9 heel to toe steps down that imaginary line. Take a series of small steps, turn yourself around, and take 9 more heel to toe steps back down that same line. And then I will demonstrate that for him. Then I'll remind him 9 heel to toe steps with every heel to toe steps. Sorry, I'm getting myself. Heel to toe with every step. Keep his arms down to his side. Look down at his feet the entire time and count each step that he takes. And then once he begins the exercise, don't stop until it's complete.
Yes, sir. Broken injury from, it was from Mexican background.
Okay, still affecting how you walk today? Sort of, yeah. Okay, well, I'm gonna have you do the walk turn and one leg stand. If you feel like you were unable to do it because of the injury, you just tell me, let me know.
Yes,
You won't do it anymore, okay? I'm sure so.
Yes, sir.
Okay, so stand right here for me. Face your car.
Yes, sir.
So what I want you to do is I want you to imagine a straight line coming from your left foot to the rear of your car. Can you imagine a straight line? Yeah, just like from your left foot, just straight on out.
Yes, sir.
As best you can. I know you have a straight line here. What is it?
I said right from the left.
Yeah, right foot front, left foot, touch heel toe. Arms down your side. Okay, don't start yet. I'll take
Sorry.
It's okay, I'll stay, don't start, okay? So get quick, right foot front, left foot, touch heel toe. Arms down your side, remain in that position until I tell you to start, okay? So when I tell you to begin, you're gonna take a series of 9 heel toe steps down that imaginary line out there.
Yes, sir.
On your 9th step, take a series of small steps, turn yourself around, take 9 more heel toe steps back down that same line, okay? It's gonna look like this, you're in this position. When I tell you to begin, 1, 2, 3. I took 3 steps. You want to take how many?
Yes, sir. 9.
9. On your 9th step, you got front foot on line. You can separate just like this. Series of small steps, just like that. You take 9 more heel toe steps. Okay. 1, 2, 3. While you're doing this, keep your feet touching heel toes every step. Keep your arms down to your side. Look down at your feet the entire time and count every step that you take.
Yes, sir.
Once you begin the exercise, don't stop till it's complete. Does all that make sense?
Yes, sir.
Begin whenever you're ready.
1, 2, 3, 4, 5, 6, 7, 8,
Yep.
And left again?
Yes, yeah.
1, 2, 3, 4, 5, 6, 7, 8, 9.
Okay, now just take a few steps back here for me.
Trooper, I'm going to show you what I've marked as State's Exhibit 2 and ask you to say what you reported as clues of impairment on the walk and turn test.
When he did his turn, that was not the way I instructed him to turn.
And what would you normally instruct him to do?
Take a series of small steps. He just spun completely around.
Now, in watching this video just now, did you note anything else that might also be a clue?
No, I did not.
And how many clues of impairment did you note on the walk and turn?
Just one.
Did you have him perform the one-leg stand test?
Yes.
I would like for you to explain what the one-leg stand test is, how you explain it, and how it's performed.
Yeah, it's a divided attention test. So I'm going to tell him to put the feet together, heels to heels, toes to toes, and arms down the other side, and then remain in that position until him to start. Then I'll go into explaining the instructions. Tell them they're going to raise either foot of their choosing, approximately 6 inches off the ground in front of them. They're going to look down at that raised foot and count out in the manner that I instruct them to. Then I would say, well, I'm going to demonstrate it for them, and then when I'm done demonstrating it, I'll tell them to keep that foot approximately 6 inches off the ground, keep their arms down to their side, make sure they're focused on that raised foot and count out in the manner that I tell them. just the turtle.
And on the one leg stand, how many collisions?
0.
Is this an accurate copy of the impaired driving report that you submitted in this case?
Yes.
When I asked this, exhibit 2.
Any objections?
No, Your Honor.
It moves.
As a result of your observations of Mr. White traveling on the Rumble Strip for 100 feet and the other marked lanes violations and the time of day, which was after 2 a.m. in the morning, smell of alcohol, the admission to having been in a bar and drinking alcohol, his later admission to well, let's go back here to this. Sorry.
Just like this, you'll those toes. Toes on the side, stay in that position till I tell you to start, okay? 1, 2. Sure you don't have to? Positive?
So at this point, does he submit to a preliminary breath test?
Yes.
Now, are you going to have any further discussion with Mr. White at this time about where he's been and how much he had to drink and things of that nature?
Yes.
And did he give you some additional information about where he was coming from?
Yeah, he stated he had 5 or 6 beers instead of the 2 that he originally stated. And then he said he was coming from Sheets. And I asked him why he was at Sheets, and he said he pulled over because he knew he should not have been driving.
You ever blown a balloon before?
No, sir.
You've never blown a balloon?
No, sir. Well, I mean, it's not a good balloon, yes. I got a birthday party, yeah.
Okay. Most people have, but there's a few that have. So what you're gonna do is you see this on this, sir, blow it to the time that you stop, okay?
Yes, sir.
Good. I'm gonna try again. You gotta take a big deep breath, seal this off, make sure the air goes into that too, not outside the side of your mouth, okay? So, good. Are you sucking?
No.
See how you sucking? Put your whole lips on.
Well, it's like catching it.
Okay, well, just put your lips on. Don't put your teeth on, okay?
Okay.
Put your lips around it, like this.
Okay.
Now you gotta see your lips on. Okay.
Yes, sir.
Okay, you got time to down. What were you doing that?
Okay.
It's new, I heard that one.
It's the one by Coleman and,
Oh, right, it's a restaurant.
yeah, it's by the Lamb and, what's the other one? So when was your last one? Okay, you want to completely honest? Okay, so completely honest, I want to say around 11:30. Okay. /12. Do you drink any liquor? I sat sheets. I'm out there for a little bit. We're down.
So you should have gone. Okay. Did you have any liquor?
No, sir.
Just 5 beers?
Yes, sir.
On the 16 ounce on the calls?
Yes, sir.
Okay. So you blew a 133. Okay, we don't have to away. Okay, so you're significantly illegal. Okay. So you're going to arrest me out.
Yes, sir.
Okay. So then turn around for me. Put the hand on my back. I'm going to use your eyes, okay? You have the right to remain silent. Anything say can and will be used in court. You have the right to attorney. Will be put upon to you. You have the right to stop answering questions anytime without having to wait. If you do decide to answer questions, you have the right to stop anytime. You understand? That's right? Okay.
So Trooper, did he initially agree that he would submit to a breath test?
Yes, he did.
And was there some problem with the machine as far as radio interference that
Yes.
invalidated?
Yeah, we tried 3 different times. We got the same error every time. So I didn't use the BMV 2055 because he did agree to give a breath sample, but due to the machine not working, wasn't gonna hold that against him, so.
You placed him under arrest there, and was that for OVI?
Yes.
And that was based on everything that you observed from the driving infractions, the field sobriety tests, your discussion with him, the smell of alcohol, his admission to being in a bar, time of day, his performance on the horizontal gaze nystagmus test, and his later admissions to drinking.
Yes.
That's all I have.
Okay,
Oh, I
Mr.
do want to admit that to the video.
Okay.
As to 3.
3. Any objection to the video?
No, Your Honor.
No, was not everyone that was video. Is it this one?
Yeah, sure.
Okay, Mr. White, you have the right to ask the trooper questions if you wish. Do you have any questions you want to ask him?
Yes, Your Honor. Trooper White, when we were back at the station and you said that you weren't going to write me down as a refusal and that do I have somebody to come pick me up? If you truly thought that I was impaired during that moment, why didn't you take me to have a urine screen or a blood test?
Well, because I can choose what test that.
Right, but is there a certain reason that you wouldn't go through every extent of the law to prove that? If you thought that I was going to be a problem, like that night or anything?
I think you wouldn't be a problem.
Okay.
No, breath test wasn't working, the breath machine wasn't working.
Right.
Just left it at that.
Right. So I guess my only statement is that the state doesn't have all the evidence to prove beyond a reasonable doubt. Just besides, I say this on video, I mean, I was out in Huntington from 6 p.m. until almost 2 p.m. that night, or 2 a.m. that night. So, I mean, your liver detoxifies within 7 hours.
Is that a question?
No, that was just a statement, Your Honor.
Okay.
And I know that there is a margin of error. Oh, okay, sorry. I apologize. I have no further questions for him.
Okay. Anything else?
No, Your Honor. We rest.
You can sit down. Now you can testify or call a witness, however you want to proceed. It's up to you, Mr. White, if you want to put on defense.
Thank you.
Okay. So the night in question.
Well, if you want to testify, you have to come up and be sworn in.
Oh, okay. True. Yes, sir. Sorry, I didn't know the procedure.
Raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth to help you God? You may be seated. State your name, please,
Kyle White.
and tell me what you want me to know about what happened on March 23rd.
On March, I guess it was the 22nd prior, because I was out that afternoon to March 23rd. I had been out with several friends and a girl that I was seeing. We went to a few bars. We were out from 6 o'clock that afternoon till 11:30 midnight that night. During that time, yes, I had consumed alcohol, about 4 to 5 beers, as stated on video. But I also had dinner. We had been walking around. I was, nowhere near acting belligerent or intoxicated or anything like that. I did, however, take a nap in my car at Sheets just to let myself cool down even more, because I'd known, like, hey, you had several drinks, but they're spaced out between 7, 8 hours time span. So by that time, I'm in college right now, full-time, as a nursing student, and I know that your liver enzymes will detoxify any blood alcohol within 7 hours.
Excuse me.
And I'd also know that I hadn't been drinking any liquor. I wasn't, acting stupid. I was fine. So I'm driving down 52. On my way home, I was headed towards my girlfriend's house. She lives in Huntington, or not Huntington, sorry, Russell, which is shown in the video. So as I'm doing this, they say that I have ran over the rumble strips. That's just an interpretation of what Trooper White is saying. There's no video evidence. I don't see how that could be admissible in court. Now, as far as, maybe me swerving over a white line once or twice, it's 2 o'clock in the morning, it's raining. I just woke up from a nap that I took in my car. I'm heading towards the house. I'm not, harming anybody. I'm not speeding. I'm not throwing my car all the way across, the highway road, the median, or anything like that. So I do understand that if he pulled me over because of the white lines, it probably did happen. I probably reached for my phone. I probably, was turning up the radio or turning on the air conditioner. It could have been a number of things. And I cooperated with the officer 100%. I was never rude. I was not, acting belligerent, violent in any way towards anybody at the whole time. And Trooper White was very respectful. I will note that. He did his job very well. He's a nice guy. I have no complaints of doing it. So we went to the station after I was arrested. I signed a paper for 90 days. He said, if you don't sign this, it's an automatic suspension for 90 days. I said, okay. So I signed it. We tried to blow into the machine 3 times. God's honest truth, I tried as hard as I could. We couldn't get that to work. He looks at me and he says, okay, this paper doesn't apply to you anymore. Throws it in the trash. He said, do you have anybody that can come pick you up? He allows me to charge my phone to call my aunt, and then he takes me to meet her. I truly believe that he's trying to do his job, but I think that if there's no urine or no blood toxin or no breathalyzer even, there's the state isn't proven beyond a reasonable doubt that I truly was intoxicated.
Thank you, Your Honor. Mr. White, you described stopping at the Sheets store. Is that on the west end of Huntington?
I believe so.
And you said you did that to cool down?
It's the one near Cookout. And yes, I stopped there to get gas and then also just rest before I drove home.
And the resting before you went home was because you had been drinking?
No, not exactly. It was because, it was a long day. We were out all day. So not only that, but like I said, I had drinks from 6 p.m. until, 11:30, 12 o'clock, which is spaced out. Is nothing. So, but yeah, I went there. got gas just to rest, give me some food. Nothing crazy. And I even let the Sheets employee know, like, hey, I'm not drunk, I'm not drugged up out here. I was like, I'm just taking a nap before I go.
That's all I have, Your Honor.
Anything else you want to tell me, sir?
No, sir.
Okay, you can sit down. Well, Mr. White, the standard, I think in just about all the states now, you don't have to be so drunk that you're erratic. I mean, what we're talking about is impaired. And I think there's plenty of evidence to find here beyond a reasonable doubt that you were impaired by alcohol. So you were very respectful with the officer, and I give you credit for that. And you were willing to take the test when the test just wasn't available. But the other evidence is enough for me to decide that you are guilty of this offense. So I'm going to give you the minimums though, because of your cooperation and respect. So the minimum fine is $375. That's what I'm going to impose. Or you pay the court costs. You get a 180-day license suspension. And that starts today. You were not under an automatic license suspension because there was no refusal. You have to go to a 3-day, I believe a 20-day jail sentence, but I'm suspending it on the conditions you go to the 3-day driving school. Because of your willingness to take the breath test but not being able to, I'm going to delete the usual community service requirement. So I'll give you a break for that. Because usually there would be 5 days of community service required. On the lane violation, a $10 fine. He'll be on 2 years of level 4 probation. Until you complete everything, you'll have a review hearing, and that's December, what is it, 20th or 23rd, I think it was. December 23rd. Yeah, December 23rd of this year. Finish everything before then, you don't have to come to that hearing, otherwise you got to be here at 9 a.m. on December 23rd. Mr. Cooper will talk to you about your probation with Mr. Major, and then he'll give you paperwork, you're free to go after that.
Your Honor, will you get the standard driving permit?
Yes, okay, sorry. I'll give you a permit. You said you're in school. Are you working also?
Yes, Your Honor. I work at King's Doctors Medical Center in Ashland. And
I'll give you a permit to drive to and from work, to and from school, to and from the 3-day school you have to go to. Is there any other driving needs you have?
just if I could go to my girlfriend's.
No, she can drive you.
Okay.
That's not an emergency. Anything else that's an emergency?
No, Your Honor.
Okay, that's all. All right, check in with probation, then you're free to go after that.
Thank you, Your Honor.
Court's adjourned.